Yes, please.
Item number 16 may kindly be adjourned for 4 weeks, my lord. There is no conflict about 2-3 years, my lord, with the petitioner, whether he is eligible or not. So I have.
Area, salary, pension, what contact do you need? You are for the petitioner. What contact you need with your client? We will adjudicate the case.
I'll take the instruction.
What instruction will you take? Let us see. You wait. Yes.
May I please, Lordship? I beg to mention item number 28 of the supply list, Your Lordship. I have taken the consent of the other side.
20?
28, you know.
Yes.
May kindly pass over for a day, Your Lordship.
Why?
Yes, sir.
Why?
Yesterday only I have received the affidavit of opposition filed by the respondent.
Okay.
So that's why.
You're going to file a rejoinder?
I will go through, if required, I will file.
Your name?
S. Deca.
Mr. S. Dekal, learned counsel appearing for the petitioner, submits that he has received the affidavit in opposition yesterday filed on behalf of the respondent. And accordingly seeks a short accommodation to go through the same, and if so advised, to file rejoinder thereof. Prayer is allowed, relist on such and such date.
Obliged, Lord.
Lordship, I beg to mention item number 19, Lordship. Lordship, I am appealing on behalf of Mr. A. Choma, Lordship. His health is not well, Lordship.
Not well.
Lordship. Lordship, kindly.
MS
K. Barpujari, Lordship.
K. Barpujari, learned counsel appearing on behalf of the petitioner, submits that due to the medical health reasons of Mr. A. Samuel, learned conducting counsel, the matter may be posted on any other date. Prayer is not opposed, relist on such and such date.
Obliged. My lord. An additional affidavit has been filed, my lord. Yesterday.
Item number, ma'am?
Item number 6, my lord.
6.
Yes.
You want to file?
Yes, no, I have filed the additional affidavit, but you may call from the.
You want it to be called?
Yes.
All right. Yes.
Please, Lordship. Lordship, with consent of the opposite parties, I pray for an adjournment in item number 4, my lord. I'm appearing for the department, my lord.
Why?
We were supposed to produce the original record, my lord. We just need just 1 week time. My lord may take it up on.
Your name?
MS K. Das, my lord.
MS?
K. Das.
MS K. Das, Learned Standing Council, Elementary.
Yes,
I am
Education.
I am on behalf of petition.
Education seeks 1 week time to produce the records as called earlier, which is not opposed by Mr.
L. Deca.
L. Dekal, Learned Counsel appearing for the petitioner. Accordingly, list on such and such date. By relist on such.
If you
Obliged.
My lord, on behalf of our counsel for petitioner, Mr. D. Gogoi, I beg to mention item 20, my lord. Any date next week may be given. Slip was circulated.
Yes. For the petitioner,
Petition.
as prayed for by Mr. I. Barthakur, Learned Counsel appearing for the petitioner on the ground that Mr. D. Gogoi is
Some difficulty.
has personal difficulty with advance adjournment slip, which is not opposed by the other side, relist on such and such date.
Lordship, let it be on the 2nd week of February, Lordship. I am appealing for the response.
Obliged.
may I please, Lordship? Lordship, I beg to mention 4, Lordship, with the consent of the other side, Lordship.
24.
24, Lordship. I'm on behalf of Mr. N. Anik Singh, Lordship. Is out of station, my lord.
Petitioner.
Any date.
Petitioner.
Petitioner. Sir.
As prayed for by MS.
B. Boysa.
B. Boysa, Learned Counsel appearing on behalf of the petitioner on the ground that the conducting counsel, Mr. A. N. Singh, is out of station, relist on such and such date. Which with consent to co-deliver. Yes. Please call the list.
For admission, item number 1.
Please, Lordship. Lordship may kindly fix a short date. The respondent side has not submitted their reply.
So you want a short date? Why you want a short date? You are the petitioner.
Submitted their
Let them speak.
She will file a reply, my lord, against our affidavit.
Is it? No. She is clearly confused with the instruction her senior has given her. She is submitting before this court that since you have not filed your return till date, therefore the matter be adjourned for a short date. She is submitting your prayer without verifying whether you actually want to file something or not.
We have not filed.
The problem, Mr. Chutia, is the fresh lawyers are not applying their mind on the instructions their seniors give. You are supposed to, ma'am, I'm talking to you. What is your name? When your seniors ask you to take time,
Lordship, my senior instructed that they have not submitted.
so then that is for them to make a prayer, right? You wait. Why are you doing their part? Have you understood what has happened or not? Because you are the petitioner. Why should you take time on behalf of the respondent? Please tell me. Yes, Mr. Chutia.
Yeah, my lord, one letter we have received, sent to the Departmental Junior Government Advocate. I am directed to enclose here a paragraph, but we asked inquiry with the Departmental. He said he has not received. So let me have inquired the office, my lord, whether paragraph will be received or not. They are
All right.
sending it.
I will not record all that.
Anyhow, after
As prayed for by Mr. T.C. Chutia, Leonard Additional Senior Government Advocate, relist after 2 weeks deliver on such and such date to enable the respondent complete return in the matter.
Item 2.
Maybe certain. Anybody there in item 2, petitioner? We are appearing in item 2. Yes, Mr. Chutia, pension matter,
yes, we have
affidavit
filed.
filed.
We have filed affidavit, my lord.
Why pension has not been released till date?
It is, my lord. I think they have not filed any reply, my lord.
Forget their reply. First of
Yes,
all,
yes,
your
yes.
ground. Why
Yes, yes,
pension has not been released?
Exactly, my lord.
Yes, have you gone through the affidavit?
No.
What is the ground for not releasing the pension in the affidavit?
Lordship, here, the main respondent,
Hmm?
1 and 4. 1 and 4 has already submitted affidavit.
Yes, I'm asking you, what is the stand of respondent number 4 in that affidavit? Which paragraph? What are the grounds for not releasing pension?
There is no, actually, in fact, it appears they have admitted it.
Where, paragraph?
Only the disputed point is that they are claiming that the petitioner will be eligible for new pension.
Is there any difficult for the learned counsels
Yes, yes.
to
Well,
answer the query posed by the court? Why is it so difficult? I'm asking a very simple question. If you don't know, say you don't know.
But Lordship,
Which paragraph in the affidavit they have stated all this? Please tell me the paragraph. Paragraph 5.
May I reading, my lord?
Yes, yes.
The petitioner which was regularized on 12/12/2006 after 2005. The petitioner's GPF reduction was made with effect from February 2008 to January 2010. An amount of rupees 300 per month, though January pay bill GPF number so and so. Since from 2005 onwards, new pension policy had been implemented for government employees. The petitioner was also one of those incumbents whose regulation came into effect from 12/12/2006. That is the manner only part. Basic, because he was joined after 1/2/2005. 1 February, 1st February 2025, those who are appearing after that manner, they will be covered by a new pension scheme. That is the case.
So now he will be covered under the new pension scheme.
New pension.
So then, but why is it not being paid under the new pension scheme then?
My lord, as per new pension scheme, my lord, he will get the gratuity and some other EPF like that, not a regular pension.
Hmm?
It is not PS deduction was made February so and so against PL, a copy of government.
Which is an amount of 52028.53 has been partially withdrawn by the incumbent from the
Yes.
NPS amount.
Yes. As per new pension scheme, my lord.
So you are going to get it up as per the new pension scheme then.
And here is the main point, Lordship, because there is specific order that depends, she will be covered by the all pension. There is
Where is that
specific
specific order?
that of- yes, it is a specific order is there.
Where?
It is on page 16, 16, annexure 4.
Page 16.
16.
Yes,
Here is a specific order. May I read, sir?
yes,
Sir,
yes.
with respect to the above and in person indication of letter so and so, letter demand, I am directed to convey the approval of Governor of Assam for creating the following incumbents in the post indicated below as regular employees with retrospective effect. This is the clear, and there is no any ambiguity.
No, this is about regularization of service of the employees. According to create, but this doesn't talk about your and this order is dated when 30th November 2005, and you
Yes.
have been appointed, you have joined when on 21/10/1992.
22. That is retrospective effect. That means from the date of joining.
The petitioner was also one of those incumbents and whose regulation came into effect from 12/12/2006. Where is the regularization order? This is only for creating post. Where is the regularization order?
As regular employees, it will cover regular employees with retrospective effect.
Mr. Counsel, page 16, the order that you are showing is indicating that I'm directed to convey the approval of the governor for creating the following incumbents in the post, so with retrospective effect, right? Now, this must be followed by another order. This is only for creating post. Mr. Chutia,
Yes, sir.
Where is-
Regulation order is not annexed here.
they must have been given another order after this.
Yes,
And it says with retrospective effect. Retrospective effect would mean from the date of joining.
that of the, but that was not retrospective effect.
No, but this on page 16 says.
No, but it is says date of joining, but he was regularized in 2006.
I have understood, but if you see the post created as regular employees with retrospective effect, what does that mean?
Post, to 16 paragraph 6, page 16. Partial modification of the order so and so that I am to convey the approval of governor for creating the flowing incumbents in the post indicated below.
As regular
Regular
employees.
employees with the retrospective effect.
What does that mean?
That is for a retrospective effect from the
Means from the date of joining.
date of appointment, madam.
Correct. Now the date of joining, if you see serial number 3 is the petitioner, 21/10/1992.
22.
Are you following what I am asking?
Yes, madam.
Huh?
Yes.
There seems to be some confusion. I think you have a proper instruction on this.
Yes, madam.
You find out because I understand the stand you have taken at in your affidavit.
Yes, madam.
But if that is your stand, this document belies your stand.
But meeting thereby ballot, post is created with effect from 1992.
Correct.
But regulation made in 2006.
No, but if that post is created with given that effect, then whether the NPS will come or the old pension will come.
Now he joined only in 1992, that is mentioned, but his service is regularized in 2006.
It will need a proper hearing.
Yes, proper hearing.
I am admitting it.
Yes.
And the meantime, I think you file an additional affidavit, you bring on record the regularization order and everything, whatever is on
Yes,
record.
yes,
You bring all that. And if you want to file petitioner, you are at liberty to file a reply affidavit. I'm admitting your case. And you file a reply in case if you want. Heard, Mr.
UC Raga.
UC Rabhal, Learned Counsel, appearing for the petitioner. Also heard Mr. T.C. Sutia, Learned Additional Senior Government Advocate for the state respondent, and Mr. You're appearing,
Accountant General.
Mr. Chakraborty, accountant, standing counsel, respondent number 6. Anybody else? The matter involves, the matter requires full-fledged hearing, admit, no formal notice as parties are represented. Since the matter involves as regards whether the NPS will be applicable in relation to the petitioner or the old pension scheme, the respondents shall file a detailed affidavit bringing on record on the date on which the petitioner services were regularized, substantiated by documents. The petitioner is also at liberty, if so advised, to file a detailed reply affidavit. Post for hearing after filing of the additional affidavit. Oh, but they didn't say. No, then don't say hearing, post on such and such date.
Item 3.
May I please, your lordship, my lord? This is the matter relates with the petitioner is the wife of the deceased husband who claims for the EPF, my lord. And accordingly, being a nominee, Annexer 4 in the record, and by the Annexer 7, the head office has marked her that she is a justified wife to get the GPF. And accordingly, the Annexer 7 shows that she is entitled for the GPF. Accordingly, it was been sent to the accounts office for her disbursement of the GPF. And account office by Annexer 8, which is an impeachment challenge before this honorable court, says that before death of the husband, he had made a nominee to her sister.
Change the nominee.
Change the nominee. 1 day. Before 1 day. Can it be justifiable when Annexer 7
The
says?
disputed question.
One more thing, his sister has
That's a
not been made.
disputed question.
My lord.
This is a
Annexer,
writ court, it's not a civil court.
my lord, if your lordship will see my Annexer 7 with all respect, my lord, page
No, but how?
27, my lord.
1 second. Yes, Mr. Roy,
I'm praying for a time because my affidavit is gone for vetting. I pray for.
let them file their affidavit.
Lordship.
As prayed for by Mr. S.S. Roy, let the CGC relist on such and such date to enable the central government file the affidavit which is stated to have been gone for vetting.
My lord, a date may be fixed with all respect.
Giving, he's
my lord.
giving.
My lord, and
Mr. Counsel, in this court, all matters gets a date. Just have some patience.
and my lord, the Annexer 8, which is the impeachment challenge, is stay, my lord.
No,
So no, my lord. It has been stated.
Okay, interim, if any,
My lord,
shall
interim
continue
order.
till the next date of listing.
My lord, deeply obliged. Kimandil, 25th of highly obliged.
Item 5.
Transfer, Mr. Saikya. Yes, Mr. Bora.
My lord, regarding the vacancy position in terms of the last letter, my lord, the government has already wrote to the concerned director, my lord. So we are
Affidavit's not required.
affidavit not required, my lord. Actually, they are against a speaking order by challenging his transfer order, my lord.
So what is this instruction, Mr. Bora?
My lord, the petitioner's contention is that his wife is serving in Nalbari, the TSR. So he wants a posting Nalbari or nearby Nalbari district. So on last occasion, this honorable court instructed me to, or directed me to obtain an instruction whether any post is available in nearby districts. So my lord, the government has wrote to the concerned director of health service seeking the vacancy position of MPW. So that has not been received by the department. So they have to sort for some time.
My lord, in the meantime, my lord, on 31/12/2025, one post failed vacant in my lord.
Let them give that instruction.
My lord,
Yes.
I'll have it next week.
I have also filed a representation, my lord, citing all the vacancies, my lord.
Can this not be then disposed of by saying that you consider a representation?
Yes, my lord, that may be done. In fact, my lord, on last
My
occasion
lord, one
also.
post
that-
is the-
Now, we will take note of that.
Fine.
I'm asking if you are satisfied, I can dispose it of by saying,
Take up in the next week, my lord. Let my friend take up the instruction, my lord.
Next week,
I have also given the copy of the representation to my friend, my lord. Paragraph 12 of my representation, my lord.
heard Mr. I.S. Chaikya, Learned Counsel for the petitioner, also heard Mr. D.P. Bora, Learned Standing Counsel, Head Department. Mr. I.S. Chaikya, Learned Counsel for the petitioner submits that during the pendency of this court, pendency of the writ petition, one post of multi-purpose worker male has fallen vacant on 31/12/2025 at Kolmoni Sub-Center under Rangla BPHC in the Kamrup district. And another post of multi-purpose worker male is going to fall vacant on retirement of the present incumbent on 31/1/2026 at Barola Sub-Center under North Guwahati BPHC in the Kamrup district. He further submits that accordingly, the petitioner has filed a representation on 6/1/2026, a copy of which has been placed before this court, to the Director of Health Service, Assam, Hengarabari, Guwahati 36, seeking transfer to either to Kolomani, to the set vacant, either to Kolomani Sub-Center under so-and-so in the so-and-so, or Barolabari Sub-Center under so-and-so in so-and-so, in terms of office memorandum dated 21/5/1987. Mr. D.P. Bora, Learned Standing Counsel, Health Department, submits that though in terms of the last court's order, he was supposed to obtain instruction as regards the vacancy position, where in the nearby districts of Nalbari, vacancy position of MPWs, na?
Yes, my lord.
MPWs in the nearby district of Nalbari. However, the same is still awaited. Be that as it may, in view of the representation placed before this court, it appears that two posts are available. Let Mr. Bora obtain specific instruction in this regard, relist on such and such date. A copy of the representation, let a copy of the representation be also furnished to Mr. Bora for doing the needful. And you place this.
There is one technical difficulty. This representation has been filed to the director, but the speaking order and that was passed by the government, joint secretary in the
You
government.
file it.
So let him file a representation to the.
Huh?
Government also have filed a representation.
That Mr. Saikia further submits, that similar representation has also been filed to
the commissioner and secretary, my lord.
the Commissioner and Secretary, Government of Assam,
My lord.
Health
Health
Department. Okay?
Need to copy of them.
Let copies of the representations be furnished to Mr. D.P. Bora, Learned so-and-so for doing the needful. You give it,
My lord.
Yes, my lord.
and I am not keeping this. You take it back. If needed, you file it by way of an affidavit.
My lord.
Right,
Also
my lord.
fixed it in the next week, my lord, before 31, my lord. Because the other post is likely to fall vacant on 31, my lord.
Next week, my lord, because that is going to be result in vacancy. So after that, my lord.
38 is a
In the
working day.
meantime, my lord, if
38.
My lord,
38.
can it be in the, on
38,
second?
you have sufficient time, Mr. Bora.
No, my lord.
You
because
get the
that-
instructions.
today is 22nd, my lord.
You have sufficient time.
Normally, after a post is fallen vacant, then only the steps may be taken.
All
So
right.
let it be on the 2nd of February.
Okay, okay, fine. Yes, next.
Obligement.
6.
May it please your lordship, my lord, here we were directed to file additional affidavit. We have filed it. See. But requisition was sent in the morning with due permission of this honorable
Not
court.
come.
After some time, my lord.
Item 7.
May it please your lordship. Lordship, the matter pertains to non-review of the suspension order.
Non-review, Mr. Burago, huh?
in the last-
26/3/2025 is a date on which the suspension was, huh?
It was 24/6, Your Lordship, of the last. 24/6.
20, date of suspension?
Date of suspension 26/3/2025
That's what.
and 9.
And it expire, the 3 months
Yes, Your Lordship.
expires on 26/6/25, right?
24.
May I correct, Madam? The date of suspension is 20/05/2025. That is the order, Madam. In Annex
Give me
20,
the date.
20/05/2025.
25,
25.
25 is suspension.
My lord, my lord,
And when does it expire?
my lord, if you go by our rules, my lord, it's 6 months, not 3 months. Our OM, the state. Yes.
6 months.
6 months, my lord, not 3.
When it says 6 months, 6 months is subsequent.
My lord, moreover, I'm coming
Which
there, my
OM
lord.
6 months? Mr. Dhar, which OM 6 months? Show me the OM.
My lord, this moment I don't have, but
No,
I
but we have been dealing with these suspension cases. Initially, it is 3 months. Only after you review it only.
my lord,
Mr.
moreover,
Chesty, am I not wrong? Am I not correct? Initially, it is 3 months, right? This court has been continuously dealing with suspension matters, Mr. Dhar.
yes, my lord, yes, my lord. I'm sorry, my lord.
If there is any change, you please enlighten the court.
No, no, my lord, 3 months, subsequent 6 months.
Correct.
But my lord, here 2 things, my lord.
So now, Mr. Dhar, don't get intimidated.
No, 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 my lord.
Be slow.
No,
Just
no.
tell me, when does 3 months expire from 25/25? Mr. Buragohan.
Lordship, Your Lordship, kindly peruse annexure 5.
Expiry. 3 months. Just count it in your fingers and give me the date. I just want to put it in the note.
My lord, 5, 6, 7, 8. It will be 8, my lord. 19/8,
8.
2025.
Yes. Now, when was the review done? Because according to Mr. Buragohan, no review, no charge sheet.
My lord, he has charge sheet. My lord, police has given charge sheet. We have focused. He has replied. It is in the last stage now.
Police is, he's under the police.
No, it was a criminal case.
Correct.
case.
But I'm not on the criminal
My
case.
lord, we have
Who has
focused.
given the suspension order?
We have
We
focused,
means
the department, my lord, Hills Area Department, my lord.
HAD.
Yes,
Has HAD issued the charge sheet?
Yes,
Please answer the question.
Focus given, my lord.
Where?
My lord, that is, we are yet to file an affidavit, my lord. It's ready. We are filing it today.
Show me.
So cause was given on 10/12/2025.
10?
12/2025.
So after expiry.
But my lord, now Ajay Chaudhary, my lord, that will come, my lord, para 23.
No.
Yes, my lord.
This court has given a lot of decision on this point. Ajay Chaudhary will come later on. But first and foremost, during the time that period, you have not given the issued the notice, charge sheet. Automatically, it will expire. That is only in the given in that situation the court have said it. Anyway, you file your affidavit. Mr. Buragohan, let him file his affidavit. Heard Mr. H. Buragohan, Learned Counsel for the petitioner. Also heard Mr. Ardhar, Learned Counsel for the respondent number 2, as well as Ms. MS S. Sharma, Learned Counsel, appearing on behalf of MS B. Sharma, Learned Counsel for the respondent number 4. Mr. Dhar submits that he has received the parawise comments and accordingly seeks a short accommodation to place the same by way of return. Prayer is not opposed. Relist the date. No, in fact, your AO is ready.
Yes, my lord, ready. I'm filing it today.
Oh, sorry. Submission to change corridor. Ardhar submits that the affidavit is ready and will be filed during the course of the day. Then next week, you take this back.
Lordship, next week. Lordship.
You have any problem?
4th of February. Lordship.
Okay.
Obliged, Lordship.
Number 8.
Deba.
Matter
Yes.
was review of suspension, my lord. It was reviewed, but after the expiry period, my lord.
Yes.
My lord, one judgment.
Suspension is on 21/7/2025, expired on 21/10/2025, no charge sheet, no review. Correct?
My lord's judgment is also there.
But later it was reviewed on 9/1/26
after the
after.
expiry period. My lord's judgment makes it clear, my lord, regarding the same.
Which paragraph?
My lord, the green flag, my lord. Paragraph 23, my lord. Green flag, my lord. The
Yes, yes, I've got it.
division bench of this honorable court also says the same, my lord. After the expiry period, it is illegal, my lord.
Yes, Mr. Bhattakur.
My instructions in the other bunch, my lord will see. Behind this, my lord, just case by the. Yes,
This one?
that bunch, yes.
Yes.
There, my lord may see, there was one more review in between, my lord. Page 7 of the document.
21 July 25.
Yes.
What is this? This is a review.
No, my lord, then if my lord looks at the
Subject to review if deemed necessary.
seventh page of the document, second last page of that document, my lord. There's a minutes of the meeting.
Yes.
Senior most secretary excise department held on 17/10/2025.
This is 25/10. This is
25/10.
Yes.
Yes. Heading says minutes of the meeting chaired by senior most secretary excise department held on 17/10. Then it says meeting was.
You
held-
file your affidavit.
Will file.
Let him file his affidavit. Mr. Sharma, these things has to be brought on record. Heard Mr. P.R. Sharma, Learned Counsel for the petitioner. Also heard Mr. I. Thakur, Learned Standing Counsel, Excise Department, and MS B. Bora, Learned Standing Counsel, BTC for the respondents. Mr. Thakur submits that he has received the instructions in order to put his return in the matter. Let the same be, let the return be completed, relist on such and such date. 20th, it's a suspension matter. You take this back. Mr. Sharma, you also take this back because sometime it gets lost. Next time you give the judgments, huh? And also give the DB judgment. But today you have only given the single.
DB
right?
judgment is also there, my lord.
Next time you give. You file your affidavit, you bring it whatever you want to say. And if you want, you file your reply thereafter.
Deeply obliged.
I'm just adding one line. Pursuant in the event the department files their return, petitioner, if so advised, shall file their reply. An endeavor on the last day, on the next date of hearing, shall be made to dispose of the instant case. These are suspension matters. You finish it. Yes.
My lord, but that 9/1/26 order, my lord, passed by the department, my lord, that is in disparity with this order, and this was never given to us,
Anyway,
my lord.
you will get your chance, Mr. Sharma.
Yes. That much.
Yes.
Deeply obliged.
Supplementary is item number 29.
Yes.
As per official lordship, no affidavit. We have already received the copy, but affidavit in opposition on the said date. What has happened?
You have
my-
received?
Yes,
You want to file a rejoinder?
no, lordship. They have admitted our grievances.
They've admitted.
Yes, lordship. Paragraph 5 of the affidavit in opposition, but it is not on record.
Lordship, it has not come on record because of certain.
What has not come? The affidavit.
Yes, my lord, because there was an cost imposed for filing the affidavit. Your lordship. We have paid the cost, but because there was certain delay in the paying of the cost, your lordship, that's why the filing section has refused to accept the affidavit yet. But we have paid the cost and will file it.
What cost for filing affidavit?
Because it was an old matter. To file the affidavit in opposition, there was an order of this honorable court that we have to pay.
Have you paid?
Yes, my lord. There is this proof of payment also.
And in this affidavit it is admitted.
Yes, my lord, out of the five petitioners, three of them have already.
Show me the affidavit. Do you have a copy?
Yes, sir.
Just mark that paragraph.
Five, lord.
You're Sharma, na?
Doctor.
Doctor, PJ.
He's a doctor.
I remember your first name. That's why I got confused with your second. Paragraph 5.
Five, lord.
5. So verification is going on.
Petitioner number 2, 3 and 8 name has been listed in the enhanced list.
So your grievances have been met.
Yes, Lordship.
Huh?
Yes, Lordship.
I can dispose it of saying this.
Yes, Lordship.
Affidavit con yet ahane, but cost to dice. So it will order query. Because why should the petitioner unnecessarily suffer? Isn't it? Heard Mr. P.J. Datta, Learned Counsel for the petitioner. Also heard Mr. N. Sharma, Learned Standing Counsel?
Yes.
Learned Standing Counsel, APDCL for the respondent. Stop. By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking approval for payment of daily wages to the petitioner. The brief facts of the case is that the petitioners are working as Sahayak since last 10 years, and they are primarily working as an outsourced worker under the Majuli Electrical Subdivision. Though the petitioners are working as outsourced casual workers, they are kept in the department with no work and no pay basis. Correct?
Yes, sir.
And no daily wages is also paid to them. The petitioners assist the regular employee without any payment apart from a mere payment for meter reading. Meanwhile, Mr. Bora, I'm disposing it off because he says that they have already admitted and verification has been done and process is on.
Yes, already admitted 3. Others verification is on. Affidavit in opposition, para 5, they have clearly stated.
So I will dispose it
Yes.
off. So you will hear it out. Ki likhila? Meanwhile, the Chief Executive Officer of Jorhat Division passed an order dated 1/7/2019, whereby some persons were appointed as outsourced casual workers on daily wages basis for a period of 89 days, and it has come to learn that on the same date, the Chief Executive Officer has issued arbitrary orders starting from 1/3/2018 till date. It is in this premises WPC 5583 of 2019 and WPC 8026 of 2019 were filed before this court. This court, by judgment and order dated 12/11/2020, was pleased to dispose of the aforesaid writ petitions with a direction for consideration of the representation of the petitioners therein, more particularly whether the petitioners are in similar footing against those who have received daily wages with other outsourced workers. Stop. Thereafter, on 7/1/2021, the office order was published, whereupon, upon considering the petitioner's representation, the office rejected the case of the petitioners for daily wages. However, the respondent admitted that the petitioners were working and are similarly situated, and the reason for denial being no separate approval have been received from the higher authority. Stop. It is in this premises that the present writ petition has been filed. An affidavit in opposition was filed on. Where is that order whereby the cost was imposed? No, that's it, like Mr. BP Bora, Learned Counsel for the petitioner, submits that the petitioners are claiming parity in terms of the office order dated 1/7/2019, whereby certain outsourced persons were allowed to perform duty in Luit Kabula area under Majuli ESD with effect from 1/3/18 to 28/5/2018. I for a period of 89 days on daily wage basis as per the APDCL norms. He further submits that the petitioners are aggrieved that although they are rendering services like these persons, their daily wages have not been granted. Don't say, I'm giving your junior's name.
Yes.
PJ Datta Koridio. He further draws the attention of the court that after per contra, Mr. N. Sharma, Learned Counsel for the APDCL, submits that though an affidavit in opposition has been filed in the instant case, however, the same having been filed after the expiry of the time, the same having been filed upon without making the payment of cost as awarded by this court on 15/10/2025, the registry of this court has not accepted the same. He, however, submits that the necessary cost of rupees 3,000 has already been
1510 order.
1510. The necessary cost of rupees 3,000 has already been deposited in the bank account of the Guwahati High Court Legal Services Committee. He further produces a receipt of the said deposit slip before this court, which is taken on record and marked as A. By relying in paragraph 5 of the aforesaid affidavit, he submits that a verification process has been started to verify the credentials of the respondents, of the petitioners, remaining petitioners. No, few petitioners have already been given.
Three of them. One, two,
Where is that thing in the affidavit?
para 5, page 29.
Oh, then you say here, by drawing the attention of this court to paragraph 5, he further submits that among the 15 number of petitioners, the name of Shri Manoj Borwa,
P2.
petitioner number 2, Shri Roman Bora,
P3.
petitioner number 3, and Shri Mridul Pegu,
P8.
petitioner number 8, have already been included in the enhanced remuneration list dated 11/8/2025. He further submits that the remaining 12 number of the petitioners were not included in the original list of outsourced workers, as the same has not been submitted by the Jorhat Electrical Circle. As such, their names were not included. However, a verification process has been started to verify the credentials of the remaining 12 number of petitioners as to whether their names can be included in the outsourced workers list. Stop. How much time will be taken for completion of this?
My lord, 1 month.
He further submits on a pointed query being raised by this court that the aforesaid verification is expected to be completed within 1 month from today. Mr. PJ Datta, Learned Counsel for the petitioner, submits that in the event the instant writ petition is being disposed of by recording the aforesaid endorsement made by the Learned Counsel appearing for the APDCL with a direction to complete the verification as assured before this court, he shall not have any objection. Correct? You're checking with him. Having heard the learned counsels appearing for the parties and having perused the materials available on record, especially a copy of the affidavit in opposition, which has been placed before this court by the parties at bar. It appears from paragraph 5, which is quoted here under quote unquote, that out of the 15 numbers of petitioner, names of 3 petitioners, i.e. petitioner number so and so, so and so, so and so, has already been included in the enhanced remuneration list in terms of office letter dated 11/8/2025, and a verification process has already been undertaken by the respondents to verify the credentials of the remaining 12 petitioners as whether their names can be included in the outsourced workers list. In view of the aforesaid, this court, in the interest of justice, deems appropriate to dispose of this writ petition by directing the respondents to complete the verification process within 1 month from the date of receipt of the certified copy of the order and in accordance with law, and pass necessary orders thereof. Huh? Ordered accordingly.
Item 30.
It will call for level. Let registry place the Mr. Counsel. The affidavit is already there with the registry, or it's with you? With the registry. Let a copy of the affidavit in opposition dated so and so be kept on record by the registry. And I think, Mr. Doctor, your affidavit, you take it back after the order is typed out. You'll take it from the court master tomorrow. Apni eto anai lo. Yes.
May it please your lordship, I am appearing on behalf of M. Das. As senior is on legs, so may the matter taken up after sentence.
All right.
Obligation.
Time being item number 6.
It has come.
Yes.
My lord, we have filed this additional affidavit where
Where is the counterpart? Mr. Chutia, you are appearing.
What does it appearing? But I am calling her. I am calling her, madam.
Let her come.
Orders item number 9.
Yes, Mr.
Yes,
Chisti.
here we have already complied. Only I have to bring it with an affidavit. By Wednesday, I will file it, lordship.
Okay, fine. As prayed for by Mr. SMT Chisti, Leonard Counsel appearing for the respondent contender number 4,
Yes.
relist the matter on such and such date to enable the respondent contender file the affidavit which he said to be prepared.
Yes, yes. Any date at the
On 10.
delay, 10.
10. Obligation.
Item 10.
Please, lordship. Also, this is a contempt petition. The petitioner is not getting his salary. This is a contempt petition.
Yes.
Regarding non-payment of salary.
Mr. Chisti, I think you are there.
I was directed by the honorable court to assist. Man, here what happened, the respondent 1 retired and 2 has already expired. So we have already accommodated them, but I couldn't file the affidavit because the present director is not a party. If your lordship direct me a judicial order to file an affidavit on behalf of the current director, then I can.
No, but the current director is not impleted.
Not impleted yet.
He has to be
It
impleted.
has to
No?
be impleted. I think.
Why are you not impleting? There has been change.
Yeah. And in fact,
Unless you bring the new incumbent, the contempt proceeding, the old will continue.
Yes, Lord.
They don't get discharged.
No, one is
But
expired.
even the new has to come. And here one has expired,
Yes.
so there can't be anything.
There is
So you take your instructions, you can. Should I record this? What you have said?
Yes, yes. No,
Sure.
you can.
You are Edas.
Yes, Miss.
Heard MS Edas, Learned Counsel for the petitioner, also heard Mr. SMT Chesty, Learned Counsel for the respondent. Mr. Chester submits that contender number one in the meantime has expired, retired.
And respondent number 2 expired.
And contender number 2 has also expired. He further submits that the new incumbent to the post of
At the Secretary, Department of School Education.
Secretary, Department of School Education to Sailova is not included in the
And
present
Director,
proceeding.
Elementary Education.
And Director Elementary Education are not included in the present proceedings. MS so-and-so seeks a short accommodation to the needful in this regard. So you do whatever is to be done.
Yes, Lordship.
Relist on such and such date.
Some more time may be given.
Did Dirk?
On 25th.
Yes.
You
Okay.
take a copy of the order,
Yes.
put it in your eye and file it.
Yes.
Item 11.
In fact, in all these cases, item 11, 12, 13, same thing.
Same.
12.
But
Oh,
they are
this-
not there, but concerns are different, but there's
where are those councils? Item 12,
Lordship 12.
you are appearing.
12.
Item 12 for Name Diba and the same respondents, Mr.
is
Chistek?
same.
Okay.
respondent.
Then 13,
13, same respondent.
but who is appearing in 13? Petitioner, council, anybody there? And none appears for the
Na-
petitioner kori dibo. Baki khini eke rakhi dibo. 14,
14, 11 is lost. 11,
14 is different.
14 is different. I'm not there.
So 11, 12 and 13.
13, yeah.
Okay.
Less Lordship.
11 also you are appearing.
No, Lordship.
So 11 council is there.
A different content.
Different. 11 none appears.
How likely?
Item 14.
Yes, Mr. Sharma.
My lord, the order is of 2016. Recently, my lord, there's an appeal which was preferred by the state, which has also been dismissed, my lord. So there's no.
But on the pretext of a pending appeal, perhaps no affidavit filed till date.
It's. Yes, my lord, that is one aspect of the matter. Appeal having been dismissed, we are now left with no option but to comply. Here, the difficulty is that, my lord, the present incumbent is not a party respondent. And the principal secretary to the finance department, he has, my lord, been transferred since long, almost 3 years ago.
Obviously, this is a 2016 matter.
Yes,
They are not
so,
going to be in that
the
position.
present commissioner and secretary to the finance department needs to be included.
But in these matters, while the matter appeal was pending, there was a stay order.
Yes,
There was stay.
yes. Yes, yes.
Okay, then perhaps it's different. Otherwise, it's very difficult. Just merely an appeal is pending, they will not comply, nothing happens, and then once the appeal gets dismissed, because now all these officers have been transferred, again the petitioner is left with, at the end of the day, the litigant is suffering
Absolutely.
because of these formalities. And now, without the new incumbent on record,
My lord.
this court also has difficulty in proceeding with the contempt, because who will be asked?
Absolutely.
Huh?
Because the person, my lord, respondent number 6, Samir Sinha, he has since been transferred.
That's correct, but
Yes.
still he will continue to be accountable.
Accountable,
That,
my-
that accountability will not automatically get discharged.
Now, my lord,
But nonetheless, the new has to come.
new has to come because of.
All right, Mr. Sharma.
I'll do the needful.
No, you do the
I'll
needful.
I
Heard,
meet my friend who can also process the matter
process what
behind-
matter?
behind the scenes, my lord. I'll be grateful, my lord, because.
That I'm sure Mr.
Mentioning-
Borpujari,
Hello, I'll be grateful.
I'm sure he will do what is required.
Already done.
That much faith this
Yes,
court has on
absolutely.
Mr. Borpujari.
That is why I.
Heard Mr. P. Sharma, learned counsel appearing for the petitioner. Also heard M. Sharma, sorry.
M. Sharma.
M. Sharma, learned counsel for the petitioner. Also heard Mr. R. Barpujari, learned counsel appearing for respondent contender number
My lord, 2, then 2.
huh?
2.
2. Mr. Barpujari submits that though the appeal preferred by the state has already been dismissed since Bilikwa, the should I say that the consideration for complying with the court's order is under process?
I have communicated.
Since the appeal filed by the state in the meantime has been dismissed, he is further time be granted to obtain instruction in this regard.
My lord.
I'm saying that. He further, then you say that he further submits that during the pendency of the contempt proceeding, yes, who has been changed?
My lord, the respondent number 2.
Post.
My lord, he was the.
Respondent contempt number 2 has been transferred out from the
No, my
post
lord,
of.
he has since been, my lord, retired.
She has been retired from
my
the post of so and so R2 post of Sailoba, and a new incumbent has accordingly been has joined the said post. However, he is not on record.
And in my submission is that, my lord, respondent number 2, as included herein, my lord, was the additional chief secretary finance department. He has been, my lord, superannuated. He is out of service. Then, my lord, the principal secretary to the government of Assam, finance department, Mr. Sinha, he was arrayed as a party respondent. He has also been since transferred. Now the present commissioner and secretary needs to be included, my lord. That is my expectation.
Duta post koi diba. One has superannuated, na?
One has
Respondent 1.
Respondent 2.
2 has superannuated, and respondent number 3 has been transferred.
But 6.
6 have been transferred.
Yes.
And new incumbents have been joined, and however are not included in the instant proceedings. Mr. M. Sharma submits that he may be allowed. He submits that necessary that he may be allowed to do the needful to bring the new incumbents on record, relist on such and such date. Prayer is allowed. Relist.
I'm grateful, madam.
25th. I'm so obliged.
You want it January?
No,
We can give it.
I'm so obliged.
For hearing, item number 15.
Yes.
On legs, lordship, for time.
Timing?
Timing, lordship.
Okay.
Deep level.
Can this matter be passed over the time? Mr. Poon is in late.
All right.
Like,
Time being.
I'm ten.
No, some urgency to go outside, so.
Then it may be.
All right, as prayed for by Mr. So-and-so, learned counsel for the petitioner, relist on such and such date.
On 11th of February. Item 17.
Lordship, on the last occasion, Lordship, Mr. Craig submitted that there are similar matters which were disclosed that. So, Lordship, those writ petition, Lordship, orders, Lordship, have got long. If he can examine as well this.
So what does this order say? In favor of the petitioner or against the petitioner?
Against the petitioner.
Against the petitioner. Have a look.
Yes.
Mr. D. Upamanyu, learned counsel, learned standing counsel, secondary education, higher education department.
I furnished the order.
Just give me one of this case. By placing reliance in the case of
Lordship, WPC 58 of 2021.
By placing reliance in the decision of the coordinate bench of this court in WPC in the case of Mrs. Julie Datta versus so and so in WPC 4937/2016. And similar and Pranab Prasad Bora versus so and so in WPC 58/2021 submits that the petitioner's case is squarely covered by the aforesaid two judgment. However, the same goes against the petitioner. Mr. So and so, learned counsel appearing for the petitioner, seeks a short accommodation to go through the same. Prayer is allowed, released on such and such date. It did you. You have a look at it. Please give him the copies. You can take these two. Did you?
I'll get it. Item 18.
Dismissal from service.
Yes, my lord.
I am paying before lordship for adjourn this case because.
Why?
My lord, conducting advocate Mr. J.I. Borbia out of station, my lord. Any
Out
date
of
may be
station.
given, my lord.
Ms. Sharma, any objection?
He had not yet appeared till date, and on the last night evening, I have talked with him. He said that he will do the matter, but now he is asking for time.
Why?
My lord, yes, yes. So last.
Ms. Sharma has prepared
Yes.
because your Mr. Barbhuya have said that he will appear, and now you're not appearing.
My lord,
Huh?
yesterday evening, talk with me and I communicate after.
I'm not interested in all this. You see, you are giving an impression to the respondent counsel that you're going to do the case. The respondent counsel has all prepared. I'll adjourn the case. You give cost. Give cost then. If you want an adjournment, you'll have to pay the cost. You cannot mislead a advocate. You want an adjournment? 3,000 rupees cost.
My lord, I am at ZB a class.
Huh?
I am at ZB a class, my lord.
I don't know about all that. If an adjournment, not you don't have to give it, whoever the learned counsel is there will have to give it. Because why a wrong communication has been given to Ms. Sharma. She has prepared, the case. Yes or no, Ms. Sharma?
Yes, I have prepared.
Yes. Then?
Otherwise, it's a 2018 matter.
Yes, and it's an
standing
old
long
matter.
Yes.
Are you going to do the case or you don't have the file? You don't have it. Lekha. Your name?
Mr. SZB a class, my lord.
MD SZB Aklas. Heard MD SZB Aklas Learned Counsel for the petitioner. Also heard MSB Sharma Learned CGC. MD SZB Aklas Learned Counsel seeks a short accommodation in the matter on the ground that the conducting counsel, Mr. J.I. Barbhuya,
Yes, ma'am.
is
Yes.
what?
My lord,
Why do you want the time?
my lord, he is out of station. My
Is
lord.
out of station. MS B. Sharma, while vehemently opposing to the said prayer, submits before this court that on last evening, MD SJB Aklas on being called
Yes.
has confirmed. You called him or
I met him in the court premises.
that upon contacting MD SJB Aklas in the court yesterday, she had confirmed that the matter shall be taken up, the matter shall be shall be conducted, the hearing shall proceed today. She has accordingly prepared the case. It is unfortunate that the counsels for the petitioner has misguided MSB Sharma in as much as she had prepared the case for today, hoping that the matter shall be taken up. However, when the matter is called, a prayer for adjournment is being pressed. It further appears that the matter pertains to 2018 and the issue involved is dismissal from service. Upon this court requesting MD SJB Aklas, who is also an advocate on record in the aforesaid case, to conduct the hearing, he however says that he has not have the brief of the case. In view of the aforesaid, the matter stands adjourned to such and such date. However, the learned counsels appearing for the petitioner shall pay a cost of rupees 3,000 to MS so and so, which shall
That must.
to the Legal Services Authority then. Well, anyway, that in view, when can it be done?
Any date, my lord, in short.
Wednesday.
After vacation.
What vacation is coming? We just finished 2 vacation. What more
My
vacation?
lord, on Tuesday.
What vacation is coming, Mr. Ajad Aklas? What vacation?
Saraswati Puja, my lord.
Huh?
Saraswati Puja.
That's a vacation? How many vacations you all want?
My lord, on Tuesday, my lord.
on Tuesday. And it is deprecated, depreciated as how the respondent councils have been misled in the matter. Eto ma pisot edit kori dim.
21.
May it please your lordship. Lordship, in this matter, my lord, my senior Miss Ibuya would like to apprise this court, my lord. So, this matter may kindly be taken up on some other date, my lord. Today, she has got some personal difficulties.
I hope the remaining matters councils are ready. I'm not going to adjourn any more matters because I see I'm only left with few. It's not even 12. This matter I'm accommodating, but not from this matter.
Private response number 5, my lord. Matter, if there is some urgency, my lord, short date may be given then, my lord.
We'll hear it today.
Yes, my lord, I am ready, my lord.
He has some difficulty, my lord, and should ask.
Heard MS
8 allocated.
MS8 Talukdar Learned Council for the petitioner, also heard MS
B. Bora.
B. Bora Learned Standing Council BTC and Mr. D. Upamanyu Learned Council appearing for higher education and
SK Sinha for
SK
private
Sinha for respondent number 5. MS Bora submits that seeks a short accommodation of the hearing on the ground of the senior counsel MSB Bhuya. Prayer is not opposed by MS A. Talukdar. However, Mr. S.K. Sinha, Learned Counsel for the respondent number 5, submit that there is some urgency in the matter. Keeping in consideration the urgency canvassed by the Learned Counsel appearing for the respondent, relist on Thursday.
Second week of February.
No. You want time, I'm giving you time today. Thursday, on such and such date. The matter, but it's a 22 matter, no?
Item 22.
Yes, Mr. Nath.
We have changed the award passed by the tribunal, my lord. The workman, my lord.
Workman's tribunal.
Yes, my lord.
Your counterpart?
Counterpart, what?
But we have not received the instruction for.
What instruction? It's a hearing matter.
No, plus government that much to do. Actually, the workmen.
Who's appearing for them?
Can I see the
MS.A. Kalita R4.
Minor. Last two occasions also, I think. They appeared, no? Last occasion they appeared. He's my learned friend.
Who is A. Kalita? MS.A. Kalita?
I think one of the ongoing content is elaborate to the parents.
No, Miss A. Kalita. No, mixing the gender. Yes, Mr. Bora, you know her.
My lord, on last occasion.
No, because if you know her, you can just give a call because otherwise I'll be left with no work.
Yes, my lord.
Can I do one thing? If suppose she doesn't come, can I make it my part, my lord, so that
Mr. Nath, what will happen then?
This too.
So you know what I can do is let Mr. Bora first give a call.
Let me wait for 5 minutes, my lord.
Yeah, you
I think
wait.
that's better. Yes,
We'll
yes,
call in
that's
the
better.
meantime the other
That's
matter.
better, my lord. Yes.
If she's ready and she's coming, then we will take it up.
My lord.
Okay.
My lord.
Next matter day too.
In this case, the petitioner has not been given his VRS. Your lord.
VRS.
Yes, the claim for VRS.
Where is Corporation Department?
Revotalize at Lex. Revotalize at Lex, lordship. Kindly matter may be passed for the time being.
Time being.
He'll be here, lordship, in a short time.
It appears that except this code, all the other codes are in priority today.
Item 25.
Right, some?
Your Lordship, my senior learned counsel, Mr. R.P. Sharma, is
engaged in another court.
See, Mr. Nath, what did I say? This is happening since morning to this here. Either respondent side or the petitioner side is in another court.
Can the item be passed over for time being? So humble.
Yes, next.
26.
Yes.
No, it is small matter now. It's what happened in this case. Petitioner was retired. After almost 10 years, they
We allow for the respondents.
imposed dies non, which is not.
Petitioner.
Petitioner retired on where 13/7/2021.
13/7.
21. Sorry. No.
What is this, Mr. Counsel?
5/10/2022. Sorry.
I don't know, but the standard of
No.
the
Sorry,
courts
madam.
have really deteriorated. Is it the holiday fever still going on or what? Huh? Yes. When retired on?
5/10/2022.
5/10/2002.
10/2000.
2000?
Oh, sorry, 36/2000. 36/2021.
36/2021
2021
retired.
as senior assistant.
As
Senior assistant.
senior. Now, what is that you're asking from?
Why not?
The
What
court?
happened in this? Because guideline was imposed for the period.
Pension not given.
Pension.
You are seeking pension.
Pension. I know.
And
Leave
the,
and, PPF, leave and
the reason is that because there was some unauthorized absence, and
Unauthorized
because notice
time.
was given.
So
However, no order has been passed
during his service,
during his service. After that, they have given.
retirement, that
After
order.
retirement. Is there any bar
Bar is there, my lord,
that after retirement they cannot pass an order? Is
Yes.
there a bar?
bar, yes, my lord.
What is the bar? Because they have passed an order treating the unauthorized absence of the petitioner with effect from 2/7/12 to 28/2/14, which is like almost 2 years. You are unauthorized leave for 2 years.
No. Yes, my lord.
Yes.
Yeah.
As dies non for all purpose.
All proper. My lord.
What is wrong in this? What is wrong in this? This is what is challenged, correct? What is wrong in this?
Wrong means, lordship, that actually after 8 years, about 8.
Yes, I am waiting.
Yes, lordship, I will. And then
I'm very sorry to say it is
the period
periods are
which effect from
taken
2000
very lightly. I'm very sorry to say.
2002, 7, 2012 to 23, 2014. The adjournment period was there. During this entire service period, he was not in the punishment. That is that should be during his period. Okay. That also to after retirement, after 2 years of retirement. 14, they have completed the proceeding, and it is about 6.
Is there any bar?
Bar means during the service period, there are service.
Is there a bar that they cannot complete these proceedings after you have retired? Once a proceeding has been started? Is there a bar?
There is a bar.
I'm repeatedly asking. If there is something in the rules, please show it. You can give it, Mr.
Yes.
Counsel, you give it.
No.
You want to show some rules?
No, madam. Yes, no bar, madam.
There's no bar.
Thing is that DP cannot be initiated after 4 years of retirement. Since the DP was initiated before his retirement.
Where is that 4 years?
But as for the pension rule, rule 21, I think.
Yes, sir.
Rule 21.
You have filed your affidavit?
Yes, sir, we have filed our affidavit.
Where is your affidavit?
Not, page 66, madam.
Page?
66, madam.
Page 66. Just take out that.
I'll put up.
No, no, you will give it. 56.
As a Calcutta High Court judgment is also there.
We'll go to the judgment later. Yes.
21C, madam.
And paragraph of your affidavit.
On that we have not mentioned, madam.
No, but what is the in your affidavit? What have you said?
Well, if a lordship comes to page number
68.
madam, yes,
Correct, 68.
Yes, madam.
Yes.
You are-
Read.
That with regard to the statement made in paragraph number 5 of the resolution, as relevant date to state the transfer order dated so and so has been revoked by the order dated by DCP, by order dated so and so, which resulted in reversion of the petitioner of so and so to his original post at Nolbari. Pursuant to the DCP's order, the superintendent of ITI Barbeta issued an order dated 12/6/2012, directing the petitioner to be ready to hand over his duty to Sri Modern Boro, Senior Assistant Borpeta, prior to his prayer for unleave with effect from so and so to so and so. However, the such handover was not carried out as per the record of the superintendent ITI Borpeta dated so and so. Since then, the petitioner has not reported for duty at ITI Nolbari and has been absent from his duty at ITI Nolbari since the last week of May 2012. The petitioner applied for unleave from so and so to so and so. This leave application was returned to the superintendent ITI Nolbari due to non-recommendation from the controlling officer and was requested to be resubmitted with necessary recommendation along with the leave account statement. Additionally, a communication was sent to the petitioner on 4/8/2012, reminding him to comply with the order dated 29/5/2012. On 30/5/2012, the superintendent ITI Nolbari informed the director that the petitioner has not attended his duties as senior assistant at ITI Nolbari since last week of May. And again, madam,
When was this initiated, the disciplinary proceeding?
This was issued on
24/7/2013. 24/7/2013.
24/7.
2013.
13.
And clarification was given, reply to 16/8/2013.
What?
Clarification, so-called reply.
Yes, one second. This where do we get this date 24/7/13? Page?
Page 94 of our affidavit.
Yes. This is the show cause notice.
Page 41.
Yes, page 94. After this, yes, what you are saying something. After this, what happened?
We have submitted clarification.
Reply. When?
16/8/2013.
13. Yes. Then?
Page number 43.
Then?
They have not given any reply to the show-cause.
Yes.
After almost 10 years, they impose punishment.
Where is that punishment order?
Page 102 of our affidavit.
Please place it.
Annexure 20.
Yes,
page
please
62.
read it. You can read it from 102. I have 102.
Annexure 20, page 62 of my writ petition.
Can you read it from 102?
Same thing, man.
Just read it.
Whereas she Tarnison Soikia, junior assistant ITI Barpeta was promoted to the post of senior assistant from the post of junior assistant and posted at ITI Nalbari with attached ITI Barpeta Bhait this office memo so dated 13/5/2010. When Tiny Soikia senior assistant ITI Nalbari was transferred to ITI Barpeta Bhait this office order memo number so dated 5/5/2012. Whereas the transfer order issued memo number so dated 5/5/2012 was revoked and C. Soika reverted back to original post in ITI Norway Bhait this office order dated 29/12/5/2012. Wherein on record it is revealed that Soikia submitted his application dated 2/7/2012 instead of joining in new place of posting ITI Norway. Where director request to comply the order dated office letter so dated 4/8/2012. Whereas the concerned head of office directed Soikia hand over the charge to senior assistant ITI Barpeta of 12. Whereas record revealed that Soikia did not join an Albai and remain absent from during the period of approval of the order without approval of the order. Whereas Soikia has asked to explain the reason or indiscipline, the relation of the duties write this office order letter so 35/2030. Soikia submitted his reply on.
All right. Yes, what is the explanation for considering or for completing everything in 2023? Because the charge sheet was also issued on 13/6/2013.
Yes, sir.
Reply to the charge sheet was given by the petitioner on 16/8/2013. After that, what happened? Why it took so many years to conclude these proceedings? Because in the meantime, the petitioner retired on 30/6/21.
No.
So what was the reason? Why were you holding this inquiry, sitting over this inquiry for so long? Then what happened? Where are those explanations? Where do I get those explanations? Because your yes, page 17 doesn't say anything, right? Page 17 after 2013, immediately it says they have considered and they found it is not satisfactory. But what happened from 13 to 2023, and especially when in 21 he retired?
Yes.
What prevented you from concluding this inquiry proceedings?
As per the allegation, my lord.
Forget the allegation. I'm asking a specific question. What happened from 2013 to 2023? Why were you not completing these proceedings, especially when in 21 the person retired? What took you so time to complete this proceeding? Where are those explanations? Forget allegation. These are the facts. It's a factual thing, isn't it? The 2013 you have given the charge sheet. 2013 he has given his reply. What happened after that? Did you appoint any inquiry officer, or whether 10, 15 inquiry officers came, retired, died, something happened? What happened?
Then I'll have to.
What you have to, by now these affidavit, they has to be filed, all these instructions should have been ready.
Then the original file will be required, madam. What happened, madam?
But that is what is required, because one of the ground is the delay. This is what you see, the premise of this whole writ petition is that the petitioner has retired. After the retirement of the petitioner, you have completed this investigation.
There is no bar.
I can understand there is no bar, Mr. Counsel, but that doesn't mean you will keep the inquiry pending for 10, 15 years and allow the person to go on retirement. And he retired in 21. You've completed in 2023. An inquiry which you started in 2013. What happened?
He was transferred once.
That is, Mr. Counsel,
Mr.
Counsel, you are now. See, the problem is people don't want to understand what is the query. There is something going on in the mind of the court. The court has not made up its mind. The court wants to see the reasons. Because only after seeing the reasons, the court can apply the judicial mind. Without seeing the reasons, how do you expect the court to exercise the judicial mind? The reasons are not stated in your affidavit. Have you stated the reasons? Nothing is stated.
No.
You don't even know the reasons.
That reason has not been explained specifically, madam. If a lordship.
And what is this, every time we are being facing with such kind of affidavits, which are neither here nor there. The issue is only that by now these explanations should have been there in your affidavit. When the matters are being taken up for hearing, again time is being given for refiling the affidavit, for additional affidavit. Matters are not getting disposed of.
Lordship, kindly speak.
And then outside everybody says that the disposals are more. Sorry, there is pendency. Now, if the officers of the court are not cooperating, how do we solve these problems?
Lordship, kindly.
Affidavit should be clear, no?
No, there is a mention in page 76, my lord, regarding your lordship.
Page
76, my lord.
70.
76 of our affidavit. The NCG requested the referral number to the DCT by letter dated 12/8/2021. Has requested the referral of file that is of impeded and not referral number 4. So to take necessary action regarding the submission of the update service book of the
This is
petitioner.
nothing. It is only one letter of 21.
Yes, ma'am. But the thing is that
You have the records.
I'll
You
bring-
can hold up the
I'll
record.
bring the record.
You see, it is important because how can an inquiry started in 2013 not complete till 2023? We will go into the legal positions later, but why was this inquiry kept pending for so long?
Lordship,
And
kindly
this
speak.
is the issue. The allegation is unauthorized leave.
Unauthorized. That's unauthorized.
Unauthorized absence.
Hello.
What took so much time for completing this inquiry?
Lordship, kindly see page 58.
All right, let them have the records. Heard, Mr.
Amen.
A. Ahmed.
Yes.
Learned counsel for the petitioner also heard Mr.
SP Das.
SP Das, Learned Standing Counsel DNCT. And anybody there?
I'm present. One.
Mr.
H of
A. Chakraborty,
one.
Government Counsel. Government Counsel R1 MS. MS. SK Medhi, your name. Is Mr. SK Medhi present before this court? What, it is so difficult for you to just tell me your name when the court is asking your name. MS R Datta, Learned Counsel for respondent number 3. On behalf of SK Medhi, SCAGANE. It appears that the records pertaining to the issue involved in the writ petition is essential for effective adjudication of the writ petition. Let the records be placed before this court by Mr. SP Das, Learned Standing Counsel DNCT on the next date of hearing, released on such and such date.
Can it be my lord 20? Or 90 or yes.
Mr. Nath's matter?
27.
It will no. You found Miss Kalita?
Yes, my lord. She's on the way, my lord. She has asked us to start our site.
Oh.
She'll be here.
Okay. It will no? Then call them at. Yeah, it took to her. 27. All right. Let me see what 27 Mr. Das whether is doing or adjourning.
No, Lordship, I'm doing the matter.
You're doing.
Lordship, very peculiar situation, Lordship.
Because till then, I think Mr. Nath Kalita will also come. It's better to start the hearing in her presence.
I'll just briefly, Lordship. Lordship may come to page number.
Who is the respondent government?
State is
there, no? Yes.
Related to the disciplinary proceeding, Your Lordship. Lordship may come to page number 115, Your Lordship.
Here, Mr. Dinath is appearing, Lordship. He's
So?
Lordship.
So?
Court number 3, Lordship.
So?
Lordship. Good timely.
So what?
Lordship,
We are
I'll just
going
move
ahead
to
with the
one
case.
Order, Your Lordship. Nothing
I'm
survived.
going ahead with the case. You are here. Other state councils are here. If you want the second, the court second brief can be given to you.
Lordship, sorry, Lordship, that copy is marked copy, Lordship.
Yes, what do you want to show from here, Mr. Das?
Yes, Lordship, this is the order that I have, Lordship, just now shown in page number 115 has been challenged by the state.
Mr. Das,
Yes, Lord.
I'm taking up your matter for final hearing.
Yes,
So
Lord.
go slowly.
Yes, Lordship. Lordship.
Otherwise, I will not follow anything. I have to author a judgment.
True.
And Mr. Counsel, in the meantime, you can send a word to Mr. Nath that the hearing has started.
Right.
If he wants, he can join the hearing. Yes.
Lordship, it's Lordship's order. It starts from page number 115. Lordship, I would like to bring to the notice of this court in page number.
Yes. This is a part of the same proceeding.
Yes, Lord.
Huh?
Yes.
This is the same
Yes.
petitioner,
Same
Bhupesh
petitioner,
Chandra Das.
Lordship.
So this was another round of
Another
litigation.
round of litigation.
What happened here? You had, that time, I think you had assailed the departmental proceeding.
Yes, Lordship. Lordship
Yes.
may come to, Lordship, I'll be try to be very brief and I'll be, Lordship may come to page number 126, Your Lordship.
Yes.
Para 33.
Yes.
As noted above, in the present case, the departmental proceeding and the criminal case are based on identical and similar set of facts, and the charge in the departmental case and the charge before the criminal court against the petitioner are also one and same. The listed witnesses in the departmental case were examined in the criminal case, and the criminal court, upon examination of such witnesses, has concluded that the prosecution has failed to establish that the petitioner accused had demanded illegal gratification from the informant.
May I please, Lord, kindly pass over for time being, Lord.
This is the last matter.
Time being, Lord.
This is the last matter. Isn't it?
That being so, in the considered
Let me hear Mr. Das, and when Mr. Nath comes, has Kalita come? She has also not come, na? Miss Kalita is also not here, right? All right. Yes.
That being so,
Did I have said here? Time being matters are similar. Okay, then let me do the time being matters. I'm told there are few time being matters. But this matter, I will take up the hearing. Huh?
Time being item number 6.
Where is Miss Bhattacharjee? She's still not here.
She was here, my lord.
All right, we'll have this matter on Tuesday. Heard MSC Chadri, Learned Counsel for the petitioner. Despite this matter being called twice, there is none appear. Oh, she's there.
So, my lord, here in this writ petition, we have challenged the executive orders which has superseded judicial order, my lord.
Compassionate appointment.
Yes, my lord. The executive order, relevant portion is at page 50.
You are challenging an executive order.
Yes, my lord. At page 53, my lord.
Yes.
Page 53, I am reading the relevant portion, my lord.
Yes.
At the bottom, column B, Roman 2. Applications, cases pending before DLCs, SLCs, wherein OM number so-and-so dated 89/2024 has not been put to challenge before Honorable Guwahati High Court as on 3/4/2025, but after 3/4/25 shall be dealt only in terms of OM number 89/2024 and shall be disposed of and intimidated to the applications by the respective DLC.
So they have
SLC.
given a cutoff date.
Yes, my lord.
You are aggrieved by that.
Yes, my lord. We have filed our writ petitions after this date, my lord, and there are orders of this honorable court. And even, my lord, after this order, there is another order by a coordinate bench, my lord, wherein, my lord, this order has been discussed, my lord. That is at page 25
This
to
says
28.
what? This says that the writ petitions which are filed after 3/4/2025
Yes, my lord.
shall be dealt as per OM dated 18/9/24.
Yes, my, which is under challenge, my lord.
Correct.
Yes, my
Now,
That means they will not.
you are now not challenging 18,924 in
That
this,
we had
no,
challenged
in this
early.
petition?
My lord,
In this petition, you are only challenging this OM, this executive order.
yes. Earlier we had
On
challenged.
what ground?
Earlier we had challenged, my lord.
No, Ms. Chaudhary, what is the ground of challenge of this executive order? Because it's a policy decision and it's a compassionate appointment.
ma'am.
There is no vested right.
Yes, my
They
lord.
are making some exception. They have given a cutoff date.
My
What-
lord,
what
they
is the
have
ground of
relied on
challenge?
only one order of this honorable court dated 3/4/2025.
Okay.
And after this, there was another order by a coordinate bench. That also I have annexed page 25 to 28, my lord.
25 to
28.
Yes.
It starts from page 26, relevant portion. Here, my this order, your lordship may kindly see the date. It is date 4/6/2025. That is after 3/4/2025. A similarly situated case here. By referring to the judgment, I am reading the fourth paragraph, relevant, my lord. By referring to the recent judgment of a coordinate bench rendered on 3/4/2025 in WPC number 342 of 25 and the batch of connected writ petitions, as well as subsequent order dated 28/5/2025 passed by Honorable Court in WPC number so and so, has submitted that the case of his client deserves to be considered by the SLC in the light of the observations made in the judgment and order dated 3/4/2025.
There is nothing,
Yes, my lord, below that. my
Ms.
lord.
Chaudhary,
Below that, my lord.
in this decision, in this court's order, ultimately the court have said that you consider by the next SLC.
And these
That's
two
all.
paragraphs were discussed, my lord. At the bottom, you have
Where are you reading?
26, the last at the
After
bottom.
going through.
Yes, my lord.
Yes.
After going through the judgment dated, so I find that although the learned single judge has clarified that the observations made therein would not lay down a binding precedent, yet there are certain directions and observations which, in the opinion of this court, would have a relevant bearing in the outcome of the present petition. So that petition was filed after that order dated 3/4/2022. Your lordship may kindly see the
What happened in 3/4/25?
my lord, relevant paragraphs were para 9 and 10. These two paragraphs have been quoted in this
Yes.
order, page 27. In the judgment and order dated 3/4/25, the learned single judge has made out the following observation in para 9 and 10, which are reproduced below for ready reference. In view of the consent of the learned counsel of the parties, all the writ petitions that are pending as of
This has been put to challenge are set aside. All the applications for compassionate appointment submitted by the petitioner shall be considered and disposed of by concerned so and so on merit by taking into consideration the varied guidelines prior to so and so and the judgments of the Supreme Court and High Court. Considering the rejection of compassionate appointment which have been put to challenge and are pending in the Guwahati High Court as on 3/4/25 are set aside. The entire process for considering the various applications for so and so and will be taken by the consumer shall be completed so and so. If the matter pertains to in other cases, so and so. Yes, it is made.
para
And,
10 was also quoted.
Yes.
After completion of the quotation, your lordship may kindly see the relevant portion, last para.
And
Page
cannot take
28.
recourse to impugn OM so and so.
Having rebut to the peculiar facts and circumstances of the case for the ends of justice, I am of the view that the petitioner's case deserves to be considered in the light of the aforesaid observations. As such, this petition is being disposed of at the stage of motion hearing for providing the petitioner's case to be considered by the SLC.
It says it shall only apply to the cases which are pending as on 3/4/2025. So this judgment of 3/4/25 is applicable to cases which are pending as on 3/4/25, not after 4/2/25.
And this order was passed after that date. This order is
Correct.
dated
4/6/25.
Yes, my lord. So here,
Now,
my lord, direction was given to place
consider.
before the SLC.
Yes.
So our cases were similar. So there.
But where is the, you see, Ms. Chaudhary, now the question before you is, there has been no adjudication on this point. It is mere disposal. The single judge has decided that your case may be, the case of the petitioner may be placed.
But here they are saying they
But
will
now
not place.
there is an executive, after this an executive order has come.
And they are saying that they will not comply with this order, they will comply with the order dated.
Where are they saying that they will not comply with
This is
4625?
reflected in the page 53, my lord.
Page 53, where are
At
they
the
saying?
bottom, my lord. Applications are pending before so and so.
Yes, they are
has
talking
not
about
been
only
put to-
3425.
Yes, my lord. After that, and the cases which have filed after that shall be dealt only with the.
In terms of
OM.
18.9.
That means they will not.
They are not
consider
saying
after
that. This is the exam. I don't see. First of all, there has been no ratio held by this court in the case of Abul Kalam Azad.
Yes, my lord.
It's a simple case of consideration.
Even our cases, I have annexed, my lord, annexure B series. Your lordship.
You'll have to
Five
come up
orders
with
I have
something
annexed.
more because you are challenging a policy decision of the government. The government have decided.
But they have decided only on the basis of one order. What about the
It is not
subsequent
about
order?
an order.
And your lordship may kindly say annexure B series. All the final orders of these petitioners.
What is your stand, Ms. Bhattacharya? Mr. Charji?
These things were also challenged in a writ petition, Lordship.
I'll come back to you.
Yes.
Yes, Lordship. The other petitioners, they also have challenged by WPC number 71125, Lordship. In that case, also the same council, they represented this, Lordship. And there also this was put to challenge. But subsequently, when the court did not enter this and was about to pass an order, they withdraw the writ petition, Lordship. This is there. Now again, Lordship, if your Lordship may kindly peruse the additional affidavit that they have filed, Lordship. Kindly peruse the date of deaths, Lordship, in page 58.
এখন additional affidavit খন আহিলে?
Yes, my lord.
What is?
Like.
Yes. 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 97, 16,
97
14, 2006, 2008, 2011.
2011, Lordship.
Yes.
And the executive order is outcome of the direction passed by this honorable court. Whether they have challenged the order that has been passed by this honorable court, Lordship. Because this executive order is outcome of this, Lordship, if you might kindly go through page 53, Lordship, executive order. May I read, Lordship?
Yes.
Whereas the government of Assam in personnel department has issued office memorandum number so dated 18/9/2020.
This 18/9/24 is still holding the field, right?
Yes, Lordship. And second paragraph, Lordship, this is most important. And whereas in the light of various judicial pronouncements, particularly in the light of order dated 3/4/2025, passed by the Honorable Court in WPC number so and similar other writ petitions, government has decided to formulate the following standard operating procedure for uniform and effective disposal of matters relating to appointment on compassionate ground. So, and accordingly on the same day, applications were invited. And certain time was allowed to file their application, whose cases were either pending in the DLC or in the SLC.
No, what happens by this executive order? Say it again. So
On the same day, Lordship, applications were invited.
on 30th August.
On 30th, Lordship.
Applications were invited of those persons.
Yes.
Whose cases are
pending either before the DLC or SLC or which are pending for consideration, Lordship. So all this is an open advertisement, Lordship, to apply, Lordship.
That they have not applied.
That I'm not aware whether they have applied or not.
Then what happened?
Then if they applied, then why they are here, Lordship?
Applied afterwards, my.
But so
But
you
Lordship.
You have applied against this.
Yes.
Then what is your grievance?
Yes, Lordship.
Applied, but as per this, my lord, as per this OM, my lord, they will not, their cases will be considered only in terms of the OM dated 18/9. That means their cases will not be placed. And there are directions of this honorable court in all these cases. Annexure B series, page 29 is the first order.
No, let us see the types of cases.
Yes.
First is number one, all documents, information received in respect of cases of compassionate appointment from the petitioners who have challenged the so-and-so, including those similar cases which have been disposed of so-and-so, pursuant to the so-and-so and subsequently forward shall be considered and disposed of. You don't come under category 1.
No, my lord.
And under category 2 also you don't come.
Our cases were pending for placing before SLC.
No, but that is not covered here, isn't it?
That's my.
Ms. Bhattacharya, where do you say that all cases pending before DLC and SLC will be called? Where do you get all that from?
Lordship,
No, your page 53, where is all that said? Types of cases is given 1 and 2.
1 and 2. Yes,
In
Lordship.
1 it says all documents, information received in respect of
cases
cases.
pending before DLCs, SLCs.
No, don't read one line, read the whole thing.
Yes, Lordship. Wherein OM number so-and-so dated
Is
18/9/24 has not been put to challenge before this honorable court.
No, please read number 1.
All documents, information received in respect of cases of compassionate appointment from the petitioners who have challenged the office. Memorandum number so-and-so dated 18/9/24, including those similar cases which have been disposed of by the Honorable Guwahati High Court, citing the judgments and order dated 3/4/2025, passed by the Honorable Guwahati High Court in WPC number 342/2025, pursuant to the notice dated 38/2025, issued by the Personnel Department and subsequently forwarded by the Personnel Department to the respective DLCs, SLCs, shall be considered and disposed of by the
This is
concerned
not
DLC,
there. Then the
SLCs.
second is applications cases
On
pending
merit,
before DLC.
taking into consideration the certain specified in para 4 of this SOP and guidelines, para 4 of the SOP Lordship, parameters, page 54.
So your case would be as per 18/9/24, as per OM. Yes.
But
It will be considered as per 18/9/24.
as per 18/9 means they will the petitioners.
We can't be helped.
And how they can presume Lordship when this matter has not yet been decided, Lordship?
Anything more, Ms. Chaudhary?
Yes, my lord. Your lordship may kindly see the orders of the present petitioners, my lord.
Yes.
It starts from page 29, first order. 5 orders I have annexed. Relevant portion starts from page 30.
Page?
Page 30, my lord. This is the order of the first petitioner.
Page 30?
Page 30. 29 is the first page. Relevant portion starts from page 30, 30.
Order for?
For placing before SLC, my lord. So here also.
It's all right.
Page 29, my lord. There are direction at page. Last page is the direction, page 32.
Direction to consider.
Direction, no, my lord, to be
Ms.
considered.
Bhattacharya, can you please take your seat now? Yes.
Page 32 at the bottom, page 7 I am reading, my lord. Accordingly, this is a similar order as my lord, the Abul Kalam Azad. Accordingly, recording the submissions made by the learned government advocate, this writ petition is disposed of, directing the SLC to consider the case of the petitioner in terms of the recommendation made by the district level committee on 30/11/2023 in its next immediate sitting. However, the case of the petitioner, if the case of the petitioner has already been considered by the SLC, the outcome of such consideration shall be communicated to the petitioner forthwith.
Yes.
So, my lord, according to this, the cases should be placed before the SLC.
Yes.
SLC may reject, that is.
Yes, yes.
So, in all these petitions, all these orders, there are 5 numbers of orders. B series, B1, B2, B3, all the same orders, my lord.
Yes.
So, my prayer is that their case should also be placed before the SLC. The SLC may reject if it is found they are not eligible.
Yes.
But as per this OM, my lord, their cases will not be placed because They have filed case after 3/4/2020.
Your ground of challenge of the executive order is only that of the fact that the executive authority has superseded the judicial order
Yes, my lord.
by relying on that order of 4.
3/4/2025 and.
No, that is to against
is-
you. 3 is against you, the next order,
Yes.
isn't
my-
it? That order was after 3. That is why you are saying,
Yes, my lord.
isn't it?
Yes,
Have I understood you properly or not?
yes.
Huh? Anything more?
No, my lord.
Okay. Heard MS SB Chaudhary, Learned Counsel, appearing for the petitioner. Also heard MS M Bhattacharjee, Learned Additional Senior Government Advocate for the state respondent. By way of the instant petition under Article 226 of the Constitution of India, the petitioner is assailing the impugned executive order dated 30/8/2025 issued by the respondent number 2 so far as column B 2 is concerned. At the outset, column B2 of the executive order dated 30/8/2025. The brief facts of the case is that the petitioners who had filed WPC 2771 of 2025, WPC number 2774 of 2025, WPC number 2769 of 2025, WPC 2635 of 2025, WPC 2762 of 2025 and WPC 2768 2025 wherein a challenge to the impugned OM dated 18/9/2024 was made, have filed the instant case jointly claiming themselves to be family members of the state government employees who died in harness or retired prematurely on being declared permanently incapacitated for service or missing and whose whereabouts is not known prior to 31/3/2017. It is the case of the petitioner that this court in the case of Abdul Qadir Bakshi in WPC 342/2025, wherein the office memorandum dated 18/9/2024 was put to challenge, was pleased to dispose of the aforesaid case by observing as under, quote unquote, paragraph 9 and 10. Page 23. It is the further case of the petitioner that pursuant to the aforesaid decision of the coordinate bench of this court, the state government, by an executive order dated 30/8/2025, issued standard operating procedure for disposal of matters of compassionate appointment, which reads as under A2A, page 53. It is the specific case of the petitioner that they are aggrieved by column 2 of column B2 of the said executive order, which is superseding the judicial orders passed by this court. It is in this premise the present writ petition has been filed. MSB SB Chaudhary, learned counsel for the petitioner, by relying on the decision of this court in the case of so-and-so in WPC 2888 of 2025, wherein this court, the coordinate bench of this court, by judgment and order dated 4/6/2025, after the judgment dated 3/4/2025 has been passed by the coordinate bench, was pleased to direct consideration of the petitioner case therein by the SLC in terms of the observations made by the coordinate bench in WPC 342/2025, particularly in paragraph 9 and 10. She submits that the executive order dated 30/8/2025 by fixing a cutoff date under column B2 shall nullify the aforesaid judgments in order passed by the High Court. Correct? This is what you are saying?
Yes.
Per contra, MSB Bhattacharjee, M. Bhattacharjee, Leonard Additional Senior Government Advocate submits that the executive order has been is a policy decision which has been duly considered and brought to provide the standard operating procedure for uniform and effective disposal of matters relating to appointment on compassionate ground in consonance with the judgments and orders passed by the Honorable Apex Court in the case of State of West Bengal versus Debabrata Tiwari, and in light of the order dated 3/4/2025 passed by this court in WPC 342 of 2025 within bracket Abdul Qadir Bakshi versus SOA and others, and other similar writ petitions thereof. She further submits that the petitioners where is that additional affidavit? That submits that the relatives of the petitioners I father on the basis of which compassionate application claim has been made are belated, and hence hence no consideration of the relief sought for in the instant writ petition be warranted by this court. I have given my prudent consideration to the arguments placed by the learned counsels appearing for the contending parties and have perused the materials available on record. It appears from the additional affidavit filed on behalf of the petitioners on 21/2026, pursuant to a direction passed by this court on 19/1/2025, that the fathers of the petitioner number 1, that the father of petitioner number 1, this Abu Ansar Ajad is who?
Is the petitioner, my lord.
And 1910 is the death of who? Father.
Father, my lord.
All these are fathers.
Fathers, my lord.
That the father of the petitioner number 1 expired on 19/10/97. Similarly, the father of petitioner numbers 2, 3, 4, 5, 6 expired on 7/11/2016, 7/12/2014, 29/12/2006, 2/5/2008, and 31/12/2011, respectively. It appears that petitioner number 1, petitioner number 2, it appears that the petitioners, upon attaining majorities, has filed their application for compassionate appointment on 16/3/2001, 4/6/2017, 13/2/2015, 4/6/2017, 21/7/2008, and 12/10/2019, respectively.
After attaining majority in the 3 petitioners.
What about
petitioner number 1, 4, and 6? Others, my lord, applied within 1 year.
Acha. So to me, to cut it down. It further appears that the petitioner number 2, 3, 2 and 3, na?
2, 3, and 5.
2, 3, and 5 immediately upon the death of their fathers, filed application for compassionate appointment, I on 4/6/17, 13/2/15, and 21/7/2008 respectively. However, in the remaining petitioners, i.e. petitioner number 1, petitioner number 4, petitioner number 6, upon attaining majority after lapse of several years, has filed their application for compassionate appointment on 16/3/2001, 4/6/2017, and 12/10/2019 respectively. Reading of the executive order dated 30/8/2025 indicates that the same has been formulated by the state government in accordance with the decision of the apex court in the case of State of West Bengal versus Debabrata Tiwari in civil appeal number 8842 8855 of 2020 and 3/4/2025 passed by the coordinate bench of this court in WPC 3/4/2025 amongst other similar cases. In order to formulate uniform and effective disposal of matters relating to appointment on compassionate ground. The aforesaid being a policy decision, this court interference is limited, except that by way of the aforesaid executive order, the executive has superseded judicial decision. No other grounds of challenging the aforesaid executive order has been made before this court by the petitioners. A plain reading of the judgment of this court, a plain reading of the judgment of this court of the coordinate bench on 3/4/2025 vis-a-vis the executive order, this court doesn't find that the state has the aforesaid contention does not hold force. The state, having considered the matter in terms of the decision passed by the apex court and various decisions of this court as reflected in the executive order itself, and having formulated an uniform standard for dealing with the cases of compassionate appointment, this court does not find any reason to interfere with the same. It has also been brought to the notice of the court that the petitioners has also applied pursuant to the applications called for by way of the executive order upon the executive or after issuance of the impugned executive order dated 30/8/2025. The apprehension of the MS so-and-so as canvassed before this court that the said petitioners shall not be the cases shall not be considered in terms of column B2 is also it cannot be a reason for interfering a policy decision made by the state government. It is also observed that the state employees related to the petitioners upon demise of their during service, on the basis of which the claim of compassionate appointments have been made, are also belated. Be it as it may, the issue involved in the instant writ petition being the validity of the executive order dated 30/8/2025, this court is not inclined to interfere with the same. Writ petition stands dismissed. Sorry. I shall edit it, later. Yes, call the time being matters.
27.
Yes.
I've been entered 27.
Mr. Nath has still not come. And what about Kalita?
Yeah.
He's there. Then help me take that matter. You are appearing in this, Mr. Chutia?
In this case, it's so good.
Lord, there is no hurdle now. There was a writ appeal, it has been dismissed. Writ appeal by the state.
All right.
If your lordship would kindly have the writ petition, my lord. 1076, na?
Yes.
Yes. Now, I'll give a little background, my lord. While the petitioner was working as a chief executive officer of Mohaldoy Jilla Parishad, a criminal case was instituted against him on the charge that he has demanded bribe and taken bribe from a particular contractor. Now, my lord,
Just 1 second. Chaudhary SSG is a qualified. Hearing to type for. তুমি এতিয়াই কয় যেতিয়া মাতিব তেতিয়া কাবাক পঠালে হয় Yes.
Lord, arising out of incident, there was a criminal case instituted against the petitioner, and there he got an acquittal. In fact, the division bench has now ordered it is a clear acquittal. Then, my lord, simultaneously a disciplinary proceeding was also initiated against him. So we moved this honorable court that since the charges in the criminal case and the disciplinary proceeding are one and the same, the charges are of grave nature, and my lord, the same set of witnesses are adducing evidence in both the proceedings. Therefore, the disciplinary proceedings should be brought to an end. Accepting our contention, my lord, your lordship passed the judgment in WPC number
Page 116.
1053 of 24.
Page 116.
Yes. Now, my lord will kindly come to 2 paragraphs that will suffice for the purpose.
33.
Page 126, 33 and 34.
Mr. Das has already shown me these 2 paragraphs. Yes.
So, my lord, that your lordship's view was that since both the proceedings are on identical facts,
To conclude the department proceeding which
in
is
other words,
pending.
what your lordship meant to us to close it. Now, despite that, my lord, they filed an IA where your lordship was pleased that they prayed for time, and the IA was, my lord,
Dismissed.
closed, dismissed, but giving them 1 month further time. Now, what
Acha,
they have done, my lord,
for concluding, they had
Concluding.
sought for an
Consistent
extension.
with the order-
Where is that
order, my lord.
order?
Page 135.
135.
Yes.
Now it is concluded, but against you.
No, not concluded.
It
I'm
is
coming
still
to-
not concluded.
Yes. They filed a writ appeal against your lordship judgment. And writ
Yes.
appeal has been upheld there for yesterday.
Yes.
Judgment has been upheld. I'll copy code. Today, page 135. Today,
Yes.
when the matter was called for, Mr. Nath, learned additional sine government advocate submits on instruction that a further period of 3 months would be required to conclude the departmental proceeding. It appears that departmental proceeding against the respondent is pending for a long time, despite conclusion of the criminal trial, resulting in acquittal of the respondent. In the considered opinion of this court, the further period of 3 months in the context of the present case appears to be unreasonable, and as such, direct the state respondents to conclude the departmental proceeding as directed earlier by this court, strictly within a period of 1 month. Now, what they did, my lord, instead of closing the DP, they have instituted another inquiry officer.
Huh?
They have instituted another inquiry officer. That is at page 137.
Yes.
When they cannot have DP, where is the question of appointing inquiry officer, my lord? Now, the division bench has clarified. Now, this order is challenged, 6th of February 25. Now, they refer to the earlier order, then subpara 4.
No, what is this 137 page? They
Page
have
137 is the order impugned in this proceeding.
what is that?
Instead of closing it, my lord, they have appointed another inquiry officer.
Oh, another appointment number. Yes.
I'm reading the fourth subpara after referring to the earlier inquiry officers being appointed. Therefore, Governor of Assam, in exercise of the power conferred under Sub-Rule 4 of Rule 9 of the Assam Services Disciplinary Rule, hereby appoints Sri so-and-so IS Commissioner and Secretary Health and Principal Resident Commissioner so-and-so to inquire into the charges against the Bhupesh Chandra Das. Now,
Yes.
when you cannot hold an inquiry of departmental inquiry, now where is the question of the inquiry officer? If a lordship will kindly have the DB order, Miller, which was passed day for yesterday.
Yes.
Now, please come to me, Lord, para 9.
Oh, I checked it. Yes.
I think one copy was given there. Written
Yes.
401.
Yes.
It was filed by the state, Miller.
Yes.
Please come to para 9.
Yes.
Para 8, Milord, para 33 of your lordship judgment is quoted. Then para 9. After having said so, the landed single judge proceeded to direct the inquiry authority to conclude the departmental proceeding present against the respondent number 1 in accordance with law, keeping in mind the observations made in the judgment within a period of 1 month from the date of receipt of a certified copy of the judgment. An attempt by the state appellant to have the time limit extended was refused by the order dated 9/1/25, but 1 month further time was granted to the state appellant to conclude the DP. Hence this appeal. We are at a loss to understand why the matter was relegated to the inquiry authority when the learned single judge, on analysis and comparison of the statement of allegation in departmental proceeding and charge sheet in the criminal case, found that they were one and the same and that continuance of departmental proceeding would be unfair. The curtains ought to have been drawn there, but nevertheless, aligning with the observation made by the learned single judge, as noted above, inquiry authorities should have concluded the departmental proceeding within the stipulated time, which somehow or other has not yet been concluded. While challenging the aforesaid judgment, Nath has made twofold argument, namely that the learned single judge did not correctly appreciate the fact that the acquittal of the respondent number 1 was not earned on merit but on benefit of doubt, and mere comparison of the statement of allegation in the departmental proceeding and charge sheet was not sufficient to come to the conclusion that there was not an iota of difference between the two, thus triggering application of so and so. Now please come to para 16. This is very important. On going through the various paragraphs of the judgment of the trial court, were of the view that acquittal was on merit, as the prosecution could not prove an important aspect of charge, namely demand and acceptance of the bribe. That apart, we have found that the learned single judge has not only made a comparison between the statement of allegation in the departmental proceeding and the charge sheet in the criminal case, but has also examined the list of witnesses and documents relied upon by the trial court, as also the inquiry.
All right. Appeal dismissed.
Yes. In fact, the division bench was of the view why your lordship itself did not pass the order. Anyway, now the matter is very simple. Now the division bench view is, as of their lordship's view is, that they cannot proceed department. So that stands concluded now. Now, if that is the position, where is the question of the appointing inquiry officer after inquiry officer? So this time lordship will quash this notice, and my lord, my promotion to the IS will be expedited.
Yes.
That's your lordship's order, my lord, directing to complete the my lord, departmental proceeding in 1 month.
Conclude. The word is conclude.
Conclude. Yes.
Para 34. Subject to correction, Mr. Chutia. You may re-verify para 34. And it has already been gone through the scrutiny of the appellate court. And the appellate court is also saying the same.
I know the fact. But
you see, Mr. Chutia, I don't know facts. Let me not go into facts.
lordship
But I go by the records.
So lordship,
now the records are before this court.
second,
The judgment of the single bench is before this court. The judgment of the division bench is also before this court. And what the state has been doing is also before this court, the impugned orders. Where is the scope of appointing inquiry officer after inquiry officer? And this court has already examined, which has been upheld by the division bench, that the continuation of this in disciplinary authority is a mockery of the disciplinary proceeding and nothing, because the criminal court has already discharged the person on the same set of allegations, same set of witness, everything compared. That exercise has already gone through by the single judge, upheld by the division bench.
That is true, madam.
I think nothing remains now.
No, I think, madam, not concluded, I think, madam.
What is not concluded? Only formal conclusion is required. This is the court could have on that day done it, but the court had given it to you because it is you who have started. After observing everything, court thought better sense would prevail. But you are again taking advantage of that situation. Instead of closing it, you are appointing an inquiry officer for what? For what inquiry? For the same allegation which the court have said that this has already been looked by the criminal court and the criminal court has acquitted.
Exactly, madam.
Then where is the scope?
Only, madam, my instruction is that, madam, because earlier inquiry officer started the Departmental posting submitted report, and their report did not involve examine the complainant and other FSL report, so they again try to complete the inquiry from the stage of evidence. That was the instruction, madam. So now, madam,
affidavits filed.
Affidavit filed, madam. So, your lordship order to conclude the within 1 month, that has been repealed, did not decline by the division bench. So my humble
No, in this writ appeal 401, both the orders were under challenge or only the extension?
The earlier order, that para 33 and 34.
That was under challenge.
That judgment.
That judgment.
Now, my lord, this honorable court, while passing this stay order, what was the view was taken? Kindly see, my lord. Now, their stand was that we have filed an appeal against your lordship's earlier order. Now, that order is gone. That order stands. So what? I mean, government is not required that every matter should be opposed, my lord. It's a case where government should say yes. Now
Can one of you place 33 and 32, 33, 34 of page 126 once again?
Yes, I'll do that. Para 126, my lord.
Page 126.
Yes. As noted above.
Para 32 also.
Yes, my lord. There is no quarrel to the proposition contended by MS Bhattacharjee to the effect the nature of criminal proceeding and departmental proceeding are wholly separate and distinct, and acquittal in criminal proceedings shall not lead to automatic discharge in the departmental proceeding. However, each case has to be judged in the context of the facts and circumstances of that case. As noted above, in the present case, the departmental proceeding and the criminal case are based on identical and similar set of facts, and the charge in the departmental case and the charge before the criminal court against the petitioner are also one and the same. The listed witnesses in the departmental cases were examined in the criminal case, and the criminal court, upon examination of such witness, has concluded that prosecution has failed to establish that the petitioner accused had demanded illegal gratification from the informant. That being so, in the considered opinion of this court, further continuance of the departmental proceeding against the petitioner is wholly unfair and unjustified. Accordingly, this court deems appropriate to dispose of the writ petition interest of justice by directing the respondent authorities to conclude the departmental proceeding which is pending against the petitioner in accordance with law, by keeping in mind observation made herein above.
What is the prayer in this case?
New case.
In the new case?
For setting aside that show cause notice at page 137.
Page
137. A prayer, writ petition, prayer, my lord.
No, in this, I think certiorari.
Yes, past that.
6/5/25.
Yes.
Appointing new inquiry officer.
Yes. A second.
Mandamus and forthwith recalled and forbid from giving effect to this.
And also 3 more, certiorari shall be issued, setting aside an impugned departmental proceeding. Earlier, on 1 or 2 occasions, they said they have filed a writ appeal against the order. So we should have it. That is how we waited also.
Yes, I don't think anything is there,
Anything
Mr.
left in this
Shipya.
matter.
finally looks like this court will have to give the final closure now.
Yes, yes.
Because you are not interested in putting a final closure.
My lord, so.
At, at two, Mr. Chaudhary, at two, I'll give the judgment in the court only. Only thing that the Supreme Court's order, this is the one, no?
Yes.
Am I? In case you are not here, Mr. Das, you may
Yes,
have to
again,
place this again.
Yes.
The Supreme Court's order.
Yes.
I'm sorry, the
Get the
division
bench
bench's order.
$25, my lord. I had to leave for outside Guwahati.
All right. Item number?
25, my lord. Can it be to your lordship's convenience date?
Your convenient date. Item 25, RP Sharma Senior Counsel assisted by
By Guru.
MS J. Sharma, the learned counsel for the petition.
On 10th February, my lord.
Anyone there for the respondent in item 25? Did you number? Huh? All right. As jointly prayed.
Mentioning a matter.
That's all right. I was not waiting for you, Mr. Das. I was just reading the affidavit of the state, just to be sure what their stand was for going ahead with the appointment of inquiry officer after inquiry officer. I think that is paragraph 12. I think, Mr. Chutia, only paragraph 12 of your affidavit, no? Okay. Heard Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr. D. Das, learned counsel for the petitioner.
DJ Das.
Huh?
DJ Das.
DJ Das, yes. Last time also I mentioned D. Das.
Yes, Lord.
You should have filed a review.
Think about it.
No, but feel free to tell the court because you see, sometimes we forget the middle initial.
Sometimes we don't like to disturb you.
No. Later on, mention it to the court master if something like this happened, because it should not, the wrong name should not go in the order. There's no difficulty in that. The present writ petition has been, oh no, এখেতৰ নামটো দি দিলা, respondents দিলা, লিখি দিছা না? The present writ petition has been instituted challenging the action of the respondent state in appointing a fresh new inquiry officer by order dated 6/2/2025 for completion of the disciplinary proceedings arising out of the disciplinary proceeding pursuant to the show cause notice issued on 9/2/2018 against the petitioner, inter alia, that since the petitioner has already been acquitted in the criminal trial arising out of the same set of allegations, the disciplinary proceedings ought to have been concluded and the respondents ought not to proceed further. It is not in dispute that earlier the petitioner had approached this court assailing the pendency of the disciplinary proceedings in WPC 1053 of 2024 assailing the pendency of the disciplinary proceedings despite the conclusion of the criminal trial. Upon consideration of the materials, including comparison of the charge sheet in the departmental proceedings and the criminal case and the list of witnesses, this court, by judgment and order dated 29/10/2024, had directed the respondent state to conclude the disciplinary proceeding within a time frame of 3 months. Relevant paragraph of the aforesaid judgment reads as under page 126, paragraph 33 and 34. It is also brought to the notice of this court that during the currency of the time frame, the respondent state had filed an interlocutory application being IA Civil 3844 of 2024 seeking extension of time, which was rejected by this court by judgment by order dated 9/1/2025. Relevant paragraph of the aforesaid order reads as under page 135A to A. The order of the learned single judge dated so and so, a first order judgment, was thereafter carried in appeal before the division bench. Division bench order is at page?
Lordship, it is not in the.
Oh, okay.
It's separate.
Okay, right.
Writ appeal 401.
Yes. The order carried in appeal before the division bench being WA 401 of 2025, wherein the learned division bench of this court by judgment and order dated 19/1/2026 was pleased to upheld the order of the learned single judge dated 29/10/2024 and declined interference thereof. It was also observed by the learned division bench that the learned single judge could have even set aside the disciplinary proceedings instead of relegating the same to the inquiring authority for concluding for bringing a logical conclusion to the disciplinary proceedings. Relevant paragraph of the division bench judgment reads as under paragraph 11, 12, 16, 17, 18, 16, 17. The grievance in the present writ petition is that, despite such directions and observations, the respondent state has appointed a new inquiry officer instead of bringing the disciplinary proceedings to a logical conclusion, and therefore such appointment is arbitrary, illegal, and intended to prolong the matter. Correct? Upon hearing the learned counsel for the parties and upon perusal of the records, this court is of the view that the writ petition is misconceived and liable to be dismissed for the reasons stated herein below. The earlier orders passed by this court, including the directions issued to conclude the disciplinary proceedings within a specified time frame, were passed essentially in the context of undue delay in concluding the departmental inquiry. The orders cannot be read as creating an absolute legal bar preventing the disciplinary authority from continuing the disciplinary proceedings in accordance with law. Next paragraph. It is well settled that criminal proceedings and disciplinary proceedings operate in different fields in the standard and the standard of proof in both proceedings is distinct. What did you write? This court, while adjudicating the continuation of the departmental proceeding initiated against the writ petitioner in the earlier round of litigation, has clearly this court This court, by anticipating the continuation of that proceeding initiated against the writ petitioner in the earlier round of litigation, has clearly, after analyzing the statement of allegation in the departmental proceeding and the charge sheet in the criminal case, recorded a finding that there was not an iota of a difference between the two and held that in such case, continuance of the departmental proceeding against the employee would be unfair and unreasonable too. It was in that context that this court has held that further continuation of the departmental proceeding against the petitioner is wholly unfair and justified. However, this court, instead of setting aside the departmental proceedings, directed the respondents to conclude the departmental proceeding, which is pending against the petitioner within a period of 1 month from the date of receipt of the certified copy of the court's order. It is observed that the state respondent, instead of concluding the departmental proceeding by concluding the departmental proceeding in favor of the petitioner in terms of the acquittal granted by the criminal court and the observation and direction as held by this court in the order dated, in the judgment and order dated so and so, comma, resorted to resorted to various tactics to delay the conclusion of the departmental proceeding. In fact, an attempt was also made to extend the 1 month time period provided by this court, which was also rejected by this court. All efforts having come to a fail, page impugned order.
It's page 137, Lordship.
137.
The impugned order means that appointing the inquiry of 137.
By order dated 6/2/2025, appointed a new inquiry officer on the ground that the earlier inquiry officer, retired on 31/12/2022, apt to reproduce the impugned appointment of the new inquiry officer, which reads as under page 137A to A. Reading of the aforesaid order, it is apparent that the state respondents were of the opinion that further inquiry is needed in this case on the ground that some serious defects crept out into the previous inquiry from the stage of recording evidences, as statements of important witnesses listed in the show cause notice were not recorded by the earlier inquiry officer who retired on 31/12/2022. And accordingly appointed Dr. Bandla Ashok Babu, IAS Commissioner and Secretary, Health and Family Welfare Department, and Additional Principal Resident Commissioner and HOD, Assam Bhavan, New Delhi, additional, to inquire into the charges against the petitioner from the stage of recording evidences. It is not understood, as when this court have already observed and held that the charges leveled in the disciplinary proceedings, having already been held by the criminal court that the petitioner is not guilty, wherein the witnesses listed in the disciplinary proceedings have also been examined. As to why the state respondent is delaying the matter. Such delay tactics adopted by the state respondent smacks of malafide, and the same cannot be allowed to be continued in the interest of justice. In view of the above, and especially the observations held by the division bench of this court as recorded herein above, I am of the considered opinion that the order dated 6/2/2025, whereby a new inquiry officer was appointed to inquire into the charges leveled against the petitioner pursuant to the show cause notice dated 9/2/2018 cannot stand in the eye of the scrutiny of law. Hence, such and such so and so is set aside and quashed. Despite the opportunity given by this court by judgment in order dated so and so in so and so, the respondents having not concluded the disciplinary proceedings and upon being satisfied that nothing survives for inquiry in view of the acquittal given by the criminal court, this court set aside the impugned departmental proceeding initiated against the petitioner by its show cause notice dated 9/2/2018 in terms of the judgment and order dated 29/10/2024 passed in WPC number 1053 of 2024 and order dated 9/1/2025 passed in IAC number 3844 of 2024, which has been upheld by the division bench of this court in by judgment and order dated 19/1/2026 in WA 401 of 2025. Writ petition, according with the above aforesaid observation direction, writ petition stands allowed.
Worship may also we have another prayer. Worship, the petitioner is due for promotion for promotion to the highest cadre, your lordship. There is a lordship, and in the affidavit of opposition, additional affidavit of opposition also, in the last order, lordship court has directed to obtain instruction. Accordingly, they have filed an additional affidavit of opposition where they have stated that he has been considered for the next year. And out of 12 officers, 4 officers are considered, 4 vacancies are there. Lordship, that process may be expedited, your lordship.
Where is that?
Our prayer,
Where is that?
our prayer is that, lordship.
No, prayer I have seen.
Yes, lordship.
Where is that
Lordship,
additional
page
affidavit?
165.
Page?
165. Because of the pendency of the disciplinary proceeding, lordship, my file was not.
One second, Mr. Das.
Yes, lord.
Page
Page 165.
Page 165.
May read from page 164, lordship, para 5. The
Before parting with the records, it is pertinent to observe that the writ petitioner amongst the writ petitioner, while challenging the appointment of the new inquiry officer and the continuance of the disciplinary proceeding, had also sought for a direction from the respondents to consider the candidature of the petitioner for promotion / appointment to the Indian Administrative Cadre. Stop. In respect of the aforesaid prayer, this court, when did this court direct that instruction?
Lordship, it is written, lordship, para 5, your lordship.
No, you said that this court, they had filed an additional affidavit because of some
Yes, lordship, page
order.
164.
Page 164. Khila. This court, by order dated 6/3/2025, directed the respondents to obtain instruction as whether the departmental candidates junior to the petitioner are being considered for nomination to IAS Cadre or not, and if so, whether steps have taken to consider the petitioner's case. The state respondents in this regard, by filing an additional affidavit on 6/6/2025, have stated as under. Page 165 now you quote, A to A. Okay. In view of the aforesaid stand taken by the state respondent, it is provided that provided that the respondents, the vacancy is already there, isn't
Yes, sir,
it?
4 petitions there.
Should I give a positive direction or?
No, no, 2023 vacancies, 2023 vacancies. If he come under
But
those.
shall consider.
Yes, if he come under.
The state it is provided that in view of the aforesaid stand taken by the state respondent in the additional affidavit, let the state respondent consider the case of the petitioner for promotion stroke appointment to the IAC in accordance with law. That should be sufficient.
Sufficient.
You consider in accordance with law.
Page in 166, Lordship, he has already been found fit.
So it's all right.
Yes, Lordship. His case should be considered.
Shall be.
Yes.
With a good fit.
Yes.
Yes.
They have said to be considered, so I have only said that.
Only the integrity certificate has been withheld.
Huh?
Integrity certificate is necessary for IS nomination, Lordship.
That
has been
process,
withheld.
in the process, they will do it.
What do you want, Mr. Das?
The integrity certificate, it is necessary for promotion to the IS. Lordship, it was withheld because of the pendency of the DP.
Now everything is gone.
Yes,
Let's release it.
Exactly, Lordship. That observation, Lordship.
Observation not necessary. It is the process of.
It is needless to be clarified that the what certificate?
Integrity certificate, Lordship, it is mentioned in page 165. Lordship, I will start from second para.
Where is it?
Second para, Lordship. Regulation 55. It's a 1, 2, 3, 4, 5, 6 line.
165.
No, 165 page number.
Yes.
Second para.
Just type it and just write that word and give it, huh?
Yes, Lordship.
So and so certificate, if not released, shall be released to the petitioner. In since the disciplinary proceedings have already been set aside by this court.
Much obliged, Lordship.
Obliged.
Pending item 30.
That
In 2015, I have joined as a driver under ASTC, my lord.
দেখা তুমি লো মানে ভাৰ্গৱক পঠাবা ভাৰ্গৱক পঠাই দিয়া তুমি কৰিবা এতিয়া যদি কিবা লং হিয়াৰিং থাকে কিন্তু এতিয়া ভাৰ্গৱে নোৱাৰিব নেকি Yes.
In 2015, I have joined as a driver under ASTC, my
You have joined as a driver.
And in 2019, a FIR was lodged against me and I was terminated. My lord, in 2021, page number 36, my lord, I was acquitted from all charges. Page number 36, my lord, paragraph number 10.
Just 1 second. Come on. Yes, please.
Paragraph number 10, my lord, I was acquitted.
Mr. Das, you may not get the order today, huh? Because since I've dictated in open court, it will take some time and you're closed from tomorrow. So on the opening, you will get it.
I was acquitted from all charges, my lord. And thereafter, my lord, in 2021, I have filed a representation, my lord. Till date, they have not allowed me to join, my lord.
You have filed a representation.
My lord, in 2012, page number 38.
Page number?
38, my lord. And my lord, in 19/9/2024, my lord, I was legs on another court, I was not present. My lord, respondent has submitted a letter 14/12/2021.
If you go on submitting, you don't even allow the court to look into the page you are referring. How do you expect this court to understand what you are saying?
My lord.
The court is human after all, not some AI machine.
Sorry, ma'am.
Huh? Or it's already that you have replaced the judges by some AI.
Extremely sorry.
Huh?
Extremely sorry.
Yes, you were relying on that representation. I'm on that representation. Yes, what happened after the representation?
My lord, in 1909
They were not allowing you to join because you had some criminal case.
My lord, I was acquitted from all
You were
charges.
acquitted. But still you are not. But you were a regular appointee or a casual appointee?
Contractual.
Contractual
They have
appointee.
terminated me under Rule 6.
So,
by
but then if you are a contractual appointee and they have already terminated, they are not bound to allow you to rejoin. You are a contractual. What is your legal basis for your claim? For the claim, where is your legal basis? Where do they have a legal right to take you back?
In 19/9/2024, they have submitted a letter stating the letter dated 14/12/2021. They have provided me a new appointment, my lord. If I join in my new appointment, I will lose my all
But
consequences.
what will you lose? You were a contractual appointee. Were you a regular appointee? Were you a regular appointee?
No, my lord.
Then, and you've been terminated. That termination is not set aside by the court. You have not challenged that termination.
My lord.
You have challenged.
Yes.
Where?
My lord,
So in this writ petition only.
My lord.
So here you are challenging that termination.
Termination, and then, my lord, I want to join reinstatement, my lord, not new appointment.
Correct. But where is your legal right? You're a contractual appointee. Where is the appointment? And then show me your termination.
My lord, page number 33.
Yes. This is your appointment?
No, my lord, termination.
Termination. This is under challenge?
My lord, this is the ending.
तुम्हारा होई गल सब होगा
He was terminated on in the year of 2019.
And when was this writ filed? 25. Why is it filed now? Why the writ petition has been filed in 25?
My lord, in 19/9/2024, I was lax on another court. That's why the respondent has submitted a letter referring that this is the reinstatement letter, but it was a new appointment and court dismissed the petition, my lord. I restored the petition.
Where is that?
My lord, order.
This case? No, huh?
No,
the writ petition is of 2021.
My lord, from 2021, I was acquitted. Then I filed this writ petition, my lord.
But what is wrong in this order of termination? He was under police custody more than 48 hours and thus his contractual service deemed to be dismissed as per Rule 6(4) of Assam Service Disciplinary Appeal Rules. What is wrong in your termination order?
And they have terminated me both following the rules, my lord. But
yes, then what? That you see, if you want this court to set aside the termination, you must bring out a case that the termination is wrongfully done. What is the wrong? I don't see any wrong.
My lord,
you are in fact you're conceding that they have followed the rules.
My lord, they have not. Without any reason, they have terminated me.
Where? What do you mean by without reason?
She's behind the bar. My lord, suspicious ground, my lord. They have arrested.
Whatever, they have done it.
After that, I was
Later on. But your appointment is also contractual. Where is your appointment? I've been asking for your appointment. You're not giving me. Where is the appointment?
My lord, appointment 30. 12/2/2025. My lord, 32.
Hmm?
Corporation Sri Rohini.
30? That is transfer.
My lord,
Transferred.
11/9/2015, my lord.
Page
31, page number 31. my lord.
30? 31 is the ID card.
Identity card. This is Sri Rohini Hazarika driver is allowed to work in maintenance.
Where?
32A, my lord. Immediate, my lord, 32B. Sri Rohini Hazarika.
32B is transferred. Miss Counsel, some other day, you please look
My
into
lord.
the facts. What
Appointment letter
kind
is
of
not-
an assistant is all this?
No, my lord.
You all have to be, it is, I'm sorry, I don't know
My lord,
what
I
is
have not
happening
done-
with the bar. You must be fully prepared in your cases.
My lord, next date I will.
Yeah, I'll give you the next date, but then the hearing matter should not be taken in this fashion.
My lord,
You
appointment
know,
letter is not
earlier,
ready.
I remember we used to sit for hours and hours, burn midnight oil before a hearing is conducted. Nowadays, I don't find any sort of preparation. These dates, the pages should be in the tip of your fingers. It appears you are reading your file here. Even now, you're reading your brief. As jointly paid released on such and such date. Next.
Item 15.
Yes, Mr. Nair?
May it please your lordship. It's a matter in which I was appointed and thereafter I have been terminated when my post was regularized by the government, my lord. My lord, there's an advertisement at page 25, my lord.
25.
25. That's a typed copy, photocopy at page 26, my lord. The post with which I am concerned with is Administrative Officer, Business Administration. My lord, pursuant to a selection process, I was selected. However, my lord, this was a contractual post for a period of 6 months. The advertisement was for that. I was appointed, my lord. At page 28 is my appointment letter, my lord. Sorry, my lord, page 29. And page 30 is the contract. If my lord comes to page 30 directly, page 30, this is 28th of February 2011. Engagement offer for Administrative Officer, Business Administration.
Your matter is going to take time
No, my lord, it's a very short matter.
because I made Mr. Nat sit for a long time. Huh?
It's very short. It won't take
Yes,
much time.
yes.
My lord, after this, I had joined my lord. After this, if my lord comes to page 46.
It's on a contractual base for 6
Contractual,
months.
Contractual, 6 months. And thereafter, it has been extended, my lord. At page 39, if my lord comes to.
Page 30?
Page 39, my lord.
Yes.
My lord, this is a letter from the Commissioner GMC to the Guwahati Development Department's Commissioner and Secretary. If my lord comes to the third paragraph from the top, I'll not bother lordship with the other
Yes.
ones. As such, creation of a post of Administrative Officer, Business Administration in GMC is essentially required in the pay scale of Grade 1 officer. The salaries of the post will be met out of devolution of the third Assam State Finance Commission, so and so. Then thereafter, clause 2, my lord, there's a grievance redressal mechanism. Lordship may come to the last paragraph.
Yes.
Government is therefore moved kindly to sanction creation of a post of public grievance officer in GMC
at an early date in the scale of a grade 1 officer. My lord, in the advertisement which Lordship had seen, there were two posts. One was administrative officer, business administration, and the other one is grievance officer. So these two posts, the government was moved to create this, to sanction the post, my lord, together. Thereafter, my lord, I have annexed the RTI documents which I have obtained under RTI, my lord. The government had taken up a staffing pattern. If my lord comes to page 46 now, my lord. This is the cabinet note, my lord.
Yes.
My lord, second paragraph, the state cabinet approved 2706 numbers of posts, including 1440 numbers of sweepers, 40 data entry operators, and 2 posts of fixed pay employees. These 2 fixed pay employees are the administrative officer and the public grievance officer.
Yes.
As per cabinet approval dated 4/9/2013, the staff position is as follows. Now, Lordship may skip the next paragraph, the second last paragraph in this page.
Yes.
Further, the state government has approved the regular posts of registrar, superintendents, and 2 fixed pay employees, namely administrative officer, business administration, and public relation officer. It should be public grievance officer. Within bracket, it's written PGO, till retirement of the incumbents. The posts of registrar, superintendent will be abolished after retirement of the incumbents. In respect of AOBA, that is administrative officer, business administration, the 4th Assam SFC recommended their posts in the scale of 8,000 to 35,000, grade pay 4,900, and so respectively.
Yes.
Since the posts of AOBA and PRO within bracket PGO have been filled by observing all formalities with concurrence of the finance department, they may be regularized in the above scale of pay with immediate effect. This was notified, my lord, at the next page, my lord. There's a notification issued by the Guwahati Development Department of the Government of Assam. Lordship may come to the and whereas the second part, and whereas, my lord.
Yes.
The state government has approved retention of the posts of registrar, superintendent, and 2 fixed pay employees till retirement of the incumbents. The last paragraph, my lord. Therefore, the governor of Assam is pleased to notify the staffing pattern of Guwahati Municipal Corporation. This staffing pattern is from the next page.
Yes.
I'm sorry, my lord, I forgot to mention. This notification at page 48 was 17 June 2014. Why this is important, I'll come to. The staffing pattern on the next page, Lordship will
Administrative officer 1.
Yes, my lord. Administrative officer.
It should have been 2, no?
No, 2. One is the grievance officer. This is under the personnel cell.
Okay.
Grievance officer is on the next page, my lord, page 50. Towards the bottom of the page, my lord, public grievance cell, public relation officer. Yes. So this has been notified.
So that has been done.
It was
so far, so good.
Yes, my lord. And page 54, my lord had already read the cabinet note that is reproduced here at page 54. Towards the end of the staffing.
Where is the problem?
Now the problem, my lord, was I had gone on leave. The impugned order was passed at page 57 on 1st of December 2014. Without any show cause, without any notice, I had been terminated.
Released,
my lord.
Why?
There was no reason at all. And my lord, that is why I had mentioned earlier, my lord, that 2 posts were created at the same time by the same notes. The public grievance officer has not been released. Only the
administrative officer.
Only the administrative officer has been released. Now the state.
But even if it is created, doesn't mean that you have to be released.
My lord.
Isn't it?
My lord, Lordship is absolutely right, my lord. However, my lord, there was some ulterior motives and therefore Lordships had interfered. It was stayed, my lord, on 16th of December. The stay order is there, my lord. 16th of December, it has been stayed.
Yes.
Now, my lord, the GMC has filed an affidavit.
Yes.
And very surprisingly, at para 7, some reason has been sought to be given. Para 7 of their affidavit. It's internal page 2 earlier, so running page, my lord, will be 5960.
1 second, huh?
My
Yes.
Now, in the affidavit, my lord, the stand taken is that it is not possible to regularize the petition at this stage. That was
It
the
is
stand
not?
taken. My lord, at page 60, my lord. Running page 60, internal page 2. This was in 2014, my lord. Paragraph
60.
60. Running page will be 60. Paragraph 7 of the affidavit, my lord.
60. Yes.
Paragraph 7. That which my lord finds it.
Yes. Para 7.
Para 7, my lord. That with regard to the statement made in paragraph 8 of the writ petition, answering deponent begs to state that the Guwahati Municipal Corporation Council body took up the matter regarding staffing pattern approved by the government via notification number so-and-so dated 17/6/2014 for Guwahati Municipal Corporation. The General Council of the GMC via resolution number 2 dated 29/10/2014 constituted a committee to examine and submit their views on the staffing pattern and also decided not to implement the staffing pattern till such final decision of the corporation, and also decided to continue with the existing schedule of posts. In this regard, a meeting was held with the 4 unions of Guwahati Municipal Corporation on 28/8/2015 after the impugned order was passed. And it was decided that the staffing pattern approved by the government should be modified. Again, this matter came up for discussion in the General Council meeting held on 16/9/2015, again after the impugned order. Secondly, the status of the Guwahati Municipal Corporation employees has been made equivalent to the staff level of the office of the Deputy Commissioner. As a result, many employees may get lower salaries. So therefore, my lord knows Govardhan Das Bhanji and MS Gill, my lord. By affidavits, they cannot bring up reasons. The reasons have to be there in the order. This is not there in the impugned order. It is not a termination simpliciter. There is some, my lord, other element which had gone into while passing the impugned order, releasing only me from the service, my lord. And there is another development, my lord. My lord, I got to know only yesterday, my lord, that in the meantime, an order had been passed, my lord, regularizing me as a regular Mazdoor. Along with 500 other persons, along with 499.
That is lowering you.
Lowering me. My lord, I'll have to challenge this order. That's different, my lord. But in this writ petition, I'm challenging the release.
But your release, you were not regularized at that moment.
My lord,
right?
But the government had, but the government had approved my regularization, and the GMC Act, my lord, I have extracted that in my.
Approved your regularization or created a post?
Created a post, created a regular post, because prior
not
to.
Against, but they in those whatever you have shown me, Mr. Nair, correct me if I'm wrong. They have not approved your regularization. What was done is that a post has been created, regular post, isn't it?
But there is another thing, my lord. They say the 2 fixed pay employees in the cabinet note as well as.
And what is the exact ground of release they are saying in this affidavit? I've not really understood that.
My lord, that is subsequent. What they are relying on is a subsequent development of 2015, when the termination was of 2000. Sorry, my lord, the release was of 2014. That cannot be taken into consideration.
Mr. Bora, why did you release the petitioner?
That impugned order is also not correct. Only thing is that if lordship goes to the impugned order page number 57, it only indicates clause number, because of clause number 7. Lordship will find it page number 30.
Page number?
30. The contract can be terminated at any time, either from one.
That's all right, but
that is the reason only given.
Huh?
The reason given.
That's the only reason given.
Page 13.
Page 30.
Lordship had read the 28th February order.
That is serial number 7.
Yes.
That is the reason given because of clause.
But where have you given the 1 month's notice?
There, no, neither in the affidavit, nothing, madam.
This has not been given. Then how can you say it is as per clause 7?
That's why, madam. That is there, madam.
Thingra. No? It's not.
No, it's not.
You can't say it is. Bora, something doesn't fit into.
Neither in the order, madam, nor in the affidavit. I think it might.
What is to be done then?
And traffic pattern might not start it. Affidavit it was filed on 2016, April 2016. Traffic pattern has not been implemented. Traffic pattern has not been implemented.
Traffic pattern has not been
implemented. Because there are some objections from the Indians and all these things.
There's not, no final
But
decision.
that has come later.
No, stuffing pattern was
That's
prior.
prior.
You see, right now your prayer is not for regularization.
No, madam.
Your
Setting
prayer
aside
is
the
only
term.
setting
Yes,
aside.
that's fine.
So I can simply set aside that
Yes,
Lord, I'll leave it to Lordship.
because that doesn't even appear to be that 1 month notice is also not given.
Compliant, madam. Absolutely.
Madam, could I be permitted to place this date? The photocopy is also.
What
yes,
is it?
My regularization as regular must do, you know. Serial along with 499 others. Serial number.
Then what is to be done? You want to
My lord, I'm just bringing it to Lordship's notice because this was not published. My lord, we were not made aware of it.
otherwise we can have it on another day. I can have it parted also. You see what is to be.
My lord, this I'll challenge because I got to know only yesterday.
What do you want to do, Mr. Nair? Tell
My lord, the termination can be set aside because for this I'll have to file a. Oh, sorry, release. I'm so sorry, my lord. Release is as good as termination. That's right, my lord. Termination, I feel is sorry again. Release is not in accordance with law. I may submit.
Mr. Bora, why don't you take a proper instruction in this matter? What is happening? Because you see, on 8/12/24, there was also I find Mr. Saikia had appeared.
Yes, that is true.
Senior counsel submits that the petitioner is under 1 month's pay notice in terms of the contract agreement.
That is clause 7, which was
That doesn't appear. Then it is also submitted that when the matter was last taken up on 5/12/2014, Standing Counsel GMC requested open instructions as to the necessity of issuance of the impugned order where there was already decision to regularize the service of the administrative officers. Where are all those instructions? Something doesn't seem to be going properly because when you have already taken a decision, instead of regularizing, you are releasing. Now you are saying staffing patterns will also not be done.
Another document, but he has been regularized in.
And he's been regularized in a different. What is happening? A foul play appears to be. I don't see. Huh?
This is apparent from releasing only me, not the other person.
Yes. Why not the other person then?
Some instruction I can give, but
What to be done?
My lord, if I may be permitted, my lord, the termination, if it is set aside, because in any case, I'll have to challenge this new order.
Then I'm not going to refer to this. You are the one who's giving me this.
My lord, because,
You are making me look into it.
no, because my lord, I'll have to make
If
lordship
you
aware.
rely on this, then I
I'm
have
not
to refer
relying.
to this.
My lord, I'm just bringing it to lordship's notice.
So that's true because tomorrow you may be questioned that you have not
Yes,
brought
my
this to the notice of the
My
court. I understand.
Termination may be set aside this in a different petition. Again, once again, sorry, my lord, release. Oh, ACS officer, legal seller. Oh, yeah, could you mention?
So this committee which was appointed way back in on 15/12/24 for revisiting the staffing pattern has revisited or not? Nothing has been done.
that instruction I don't have it on 16. That
Construction, I don't have it right now, my lord.
But my lord, this order, my lord, it says that the staffing pattern is approved by the government. Yes, 2021.
All right, let us try.
My
Heard Mr. P.D. Nair, Learned Counsel, appearing for the petitioner. Also heard Mr. S. Bora, Learned, you're appearing as standing counsel.
Standing counsel, no, all
Learned-
the respondents.
Huh?
All the respondents.
Standing counsel GMC.
GDD. GNC and GDD, madam.
And GDD,
Guwahati Development Department.
Guwahati Municipal Corporation GMC and Guwahati Development Department GDD, standing counsel. By filing the instant writ petition, the petitioner is assailing the impugned order dated 1/12/2014 issued by the respondent number 4, whereby the petitioner was released from service of the respondent number 3. The brief facts of the case is that the petitioner was appointed as an administrative officer within bracket business administration in the Guwahati Municipal Corporation, hereinafter referred to as GMC, through a regular selection process with the approval of the Government of Assam, initially for a period of 6 months, and thereafter the same was extended till the finalization and acceptance of the staffing pattern of the GMC by the government. The Government of Assam, with the concurrence of Finance Department and the Guwahati Development Departments, had accepted the staffing pattern of the GMC, and the State Cabinet had approved the regularization of the petitioner in the post approving him the time scale of pay till his retirement. While the matter rested there, the respondent number 4, Commissioner GMC, by order dated 1/12/2014, suddenly released the petitioner from service of the corporation, stating the same to be in the interest of public service. Aggrieved by the aforesaid release/termination order, the present writ petition has been filed. Mr. Nair, Learned Counsel for the petitioner, submits that the aforesaid release is totally bad in the law, as the same is done without issuing any notice or giving any opportunity of being heard to the petitioner. He further submits that the Government of Assam, having already accepted the staffing pattern and the State Cabinet having approved the regularization of the petitioner, the service of the petitioner ought to have been regularized in the said post of Administrative Officer, Business Administration. However, instead, the respondents have resorted to release the petitioner for vested interest. Okay. He further submits that along with the petitioner, there has been another officer who has been working as
public grievance
officer, which post also was in respect of which also the Government of Assam and the GDD had accepted the staffing pattern of the GMC and had regularized and had approved the regularization of that person. though the state respondent had released the petitioner, however, the said person is still continuing. Right? This
Ma'am.
is what you have
Yes, ma'am.
submitted.
Yes, ma'am. Yes.
Per contra, Mr. Bora submits that the stuffing pattern is not yet finalized, and the service of the petitioner having been in the nature of contractual arrangement was terminated in terms of the contractual appointment by giving the 1 month notice. Having heard the learned counsels appearing for the parties and having perused the materials available on record, it appears that the petitioner, while being engaged as administrative officer, business administration, by the Commissioner GMC by letter dated 28/2/2011 on purely contractual basis for a fixed period of time, with the condition that the contract can be terminated at any time from either side with 1 month's notice, was also later on extended. The release order, page.
Ma'am. Page 57. Like photocopy is a bad one, my lord, 58. 57 is a typed copy.
The release order dated 1/12/2014 reads as under A to B, page 57. Apparent reading of the aforesaid release order that the petitioner was released from his service with immediate effect, i.e. 1/12/2014. The contention of Mr. Bora that the 1 month notice as contemplated under the terms and condition of the contractual engagement dated 28/2/2011 was given to the petitioner on the face of record is misconceived. It is further apparent from the letters enclosed in the writ petition, particularly Annexure P8 dated 5/9/2011. You please check this, I think I'll start with 37.
Yes, my lord. Yes, my lord.
Then Annexure P9.
Yes, my lord.
P9 is
P9 is the
not
RTI
required.
reply.
P9 is not required.
My lord may start from 35.
35?
35, my lord. This I have not read, my lord. But
Annexure P7, page 16/8. What's the date?
16/8/2011.
Then,
my lord, this was approved, my lord, at page 37, my lord, 5th September 2011.
তুমি কেনেকে আৰম্ভ কৰিলা? They don't say particularly that the petitioner's post has been regularized, that the state government has approved the regularization of the petitioner and has also provided the staffing pattern of GMC in respect of the aforesaid post. Correct? Subject post. Stop. Then you start from page 35. It appears that the Office of the Commissioner, GMC, by letter dated 16/8/2011,
Had sought for extension.
Huh?
Had sought for extension.
Had sought for extension of term of contract for the post of administrative officer and public grievance officer in GMC. One of the posts which the petitioner was holding. It further appears that the Commissioner and Secretary to the Government of Assam, by letter dated 5/9/2011, was pleased to extend the service of the petitioner and the public grievance officer till finalization of the staffing pattern by the study group and its acceptance by the government. It further appears that page
46, my lord. That's a cabinet note.
That the state cabinet thereafter approved 2706 numbers of posts, including 1440 numbers of sweepers, 40 data entry operators, and 2 posts of fixed pay employee, i.e. administrative officer and public relations officer.
Within bracket, public grievance.
Public grievances. It further appears the state cabinet further approved the regular post of registrars, superintendents, and 2 fixed pay employees, namely administrative officer within bracket business administration and public relation officer within bracket PGO till retirement of incumbents.
Page 48.
It is further observed that it was also recommended that since the post of administrative officer and PRO PGO have been filled up by observing all formalities with the concurrence of finance departments, their services may be regularized in the above scale of pay with immediate effect.
48, man.
Thereafter, the Government of Assam, GDD, by notification dated 17/6/2014, was pleased to notify the staffing pattern of GMC. Correct?
My lord. My lord.
A perusal of the staffing pattern of GMC as enclosed part of Annexure P12 in the writ petition, it appears that against the post of administrative officer within bracket BA, 1 staff has been approved, and in respect of PRO, 1 staff has also been similarly 1 staff has been approved in the public grievance cell.
Page 54, if my lord.
The last part you want, the
Yes,
same.
madam. Yes, madam.
It further appears that while notifying this is that same thing.
Yes, it's a continuation.
While notifying the staffing pattern, the additional chief secretary to the Government of Assam, GDD, has observed that since the post of AO, BA, and PRO, PGO have been filled up by observing all formalities with the concurrence of Finance Department, their services may be regularized in the above scale of pay with immediate effect.
Also the second paragraph.
And that in respect of administrative officer, BA, and PRO, PGO, 4th Assam State Commission recommended their post in scale of has observed that in respect of administrative officer, business administration, and public relation officer, PGO, the 4th Assam State Finance Commission has recommended their post in the scale of rupees 8,000 to 3,500 dash GP rupees 49,000 and rupees 8,000 to 35,000 dash GP 47,000. It page 54. And accordingly has opined that his sins বুলি যে কৈছো ইয়াত add কৰি দিবা।
My lord, I meant also, my lord, the paragraph above it, my lord, till retirement of the incumbents.
This I have already stated once, I think.
My lord, my lord. Then it's
I have already said one. লাগিলে আকৌ এইটো ওপৰত আছে এই বস্তুটো মোক তুমি দেখুৱাই দিবা। Yes, then
my lord, the termination order. Sorry, release order, my lord.
it appears that despite the staffing pattern being notified and the service of the petitioner having been regularized, as indicated above, suddenly the Commissioner GMC by order dated 1/12/2014 issued the impugned order whereby the service of the petitioner was released from service with immediate effect in total contravention of the contractual engagement of the terms and condition of the contractual engagement. The grounds stated in the affidavit in opposition that it is not possible to regularize the petitioner in the post of administrative officer, business administration, appears to be cannot be accepted in view of the fact that the state government had already approved the regularization of the post of the petitioner and has also notified the staffing pattern. The stand of the respondent that the staffing pattern decided by the government required modification and accordingly was decided in a meeting held on 16/9/2015. However, the same is yet to be finalized, appears to be also cannot be also of any consequence in the instant case, inasmuch as the service of the petitioner appears to have been already regularized. I think I'll simply say that. Surprisingly, it has been informed by Mr. P.D. Nair, learned counsel for the petitioner, that during the pendency of the instant writ petition, the petitioner has been regularized
As a regular Mazdoor.
as a regular, I can't read this.
My lord, it's
As a regular Mazdoor
Mazdoor.
by letter dated 10/2/2021. However, since there is no challenge of the aforesaid order in the present writ petition, this court shall not comment on the aforesaid order and leaves the same for to be decided in an in the event an appropriate challenge is being presented before the competent forum. Having said so, this court finds the release order bad in law, accordingly set aside and quashed. Allowed. This you take back.
Deep here. 22.
By now, Mr. Nath, I don't know how much more energy is left.
With your lordship, this morning is not easy. It's not easy, my lord.
To dispose of.
Not easy.
Because you see,
disposing of. Hearing the matter and then keeping it reserved, and then that's a different issue.
And the other problem is the stenographers are getting burdened by the disposals, no? I only have 3 stenos. Well, most of the other courts have 4 because of the scarcity of stenographer. Now that is why I'm conscious of how many they are taking, because from tomorrow for 4 days court will be closed. Saraswati Puja, then Saturday, Sunday, then Republic Day.
My lord, I've got no issue.
Anyway, what is your case?
My case is, my lord.
Mr. Nair, you will not get your order today.
He's happy if he gets up after 1 week also, doesn't matter. He got back to me, my lord.
Yes, Mr. Nair. Mr.
My lord, the response.
Nath.
The petitioner here is a, my lord, Assam Cooperative Society, jute mill, my lord, in Shilgat. It's a jute mill. It's a dead now mill now. It's not working since a few months, I think. And the respondent number 4, he's a workman. He's the president. He's the president of the union, my lord. So there is always little bit of advantage of being president, my lord, in the office, high-handedness. What he did, my lord, he remained absent in the office.
He
remained absent from his work because without any notice, nothing from his duty. Then we give him a notice. Then he gave a reply. As per the rules, guidelines, my lord, there is a doctor in the mill. If you got any problem, come to the doctor in the mill and give your certificate. If it's right and wrong, they'll decide. My lord, he gave a reply. It is not mill's doctor, someone else. Ultimately, it was not satisfied on his reply. Then domestic inquiry was started. On 3 occasions, notice was given to him to appear in the inquiry, my lord. He did not appear in the inquiry report. So ultimately, he was terminated from service. Then the matter was taken to the labor court by the smoke 4. The labor court dealt with the matter, and while dealing with the matter, the labor court came to the conclusion that the management did not furnish certain documents in the labor court, including, this is important, the inquiry report. All the other documents, what learned tribunal has said, I find it is there. He marked as exhibit 1, 2, 3, 4 like that. But basically, I find the inquiry report is not furnished. So, my lord, also because of non-furnishing of the documents, the tribunal says, don't have presumption under 114 Evidence Act. I have presumption, my lord, against the management. So order for reinstatement. Now, if I show to lawsuits, my lord, first of all, what's the main issue? The main issue is
initially the preliminary inquiry was held as regards the validity of the domestic inquiry.
No, it was a domestic inquiry was held.
Correct. Now, before that was challenged by the workmen
Exactly.
in the
labor court.
in the labor court.
Labor court.
So the labor court,
Yes.
as a preliminary issue, has held the validity of the domestic inquiry.
Yes.
And then the labor court found that it is in violation of natural justice because the inquiry.
No.
Huh?
That document was not produced before the labor court.
Which document?
The inquiry report. And the document was also not furnished to the workmen. The 2 things, my lord. And because of that, labor court says, don't have presumption. Because of this, they don't furnish the documents. I presume that this, my lord, this is illegal.
Where is that order?
My lord, page number 1.
That is challenged before this court.
Yes. It starts from page 162. Relevant part, my lord, if your lordship kindly.
160?
62. Lordship may see from 167. Because discussion and decision is here. Regarding issue number 1, and that's the main one. Whether termination is legal or illegal. Page 167.
Yes.
Let me read, my lord, from there. Issue number 1, then paragraph, second paragraph. Workman was regular employee, such the next. Workman Jayanto Borkatoki examined him as W1. He has testified in his chief that he was the elected president of the trade union, which is a registered trade union. As he was always advocating for good cause of the association, as such, the management is always hostile to him. He has also testified that management issued him exhibit BC letters alleging his absence from service without intimation. The letters issued by the management clearly reflected that it had been threatening him with intention of termination of service. Accordingly, the management issued exhibit C, letter of termination of service upon such and such. Next is important. During cross-examination, he denied the suggestion that he procured a false medical certificate and submitted to the management. He also replied that when a workman proceeds on medical leave, he has to be examined by a doctor of the management company. He has admitted that he did not get him medically checked up by doctor of the jute mill. Instead, he got medically checked up at Jaklamanda Hospital, but he did not submit the medical document to show that he was examined by the doctor at Jaklamanda Civil Hospital. He was not present for domestic inquiry. He has also denied suggestion that he did not submit a reply. Then Bimal Kamal Sharma, management, my lord, suggested his evidence is, he has testified inter alia that following several complaints against the applicant workman for his immoral and illegal activities against the interest of the management, and also on the basis of complaint of senior assistant such and such, the workman misbehaved with him in the presence of jute suppliers and threatened to extinguish his life. Exhibit 2 shock of notice issued to him. He has also testified that workmen created disturbing situation in the mill campus for which he had given an undertaking before SDO Civil Collier. He has also found himself absent from duty without any intimation to the management authority. Under the above backdrop, the workman was issued shock cause notice dated such and such. On his failure to reply, the departmental domestic inquiry was ordered, and he was issued Exhibit 3 notice to appear before the inquiry. Thereafter, they remained absent after lockdown from 7/5/20. He was issued reminder to appear before the domestic inquiry after he had been issued Exhibit B reminder notice. This time also he did not appear. Therefore, the management, after conducting domestic inquiry, found him guilty of serious misconduct and terminated him from service after overseeing all opportunities to him. During cross-examination, MW1 testified Exhibit B leave application submitted by the workman on medical ground was not granted as he did not properly file the petition. He has admitted exhibits such and such were submitted by the workman. He has also admitted that findings and report of the inquiry officer were not furnished to the workman as I submitted, my lord. It is relevant to mention here that petition dated 2A of the workman does not reflect the necessary particulars about holding of domestic inquiry, and the inquiry was unfair, illegal against the settled principle of law. Perhaps these were due to non-application of mind or lack of knowledge of landed representative of the workman. Such omission of material particulars on which the foundation of this case is based had taken place. It may be mentioned here that in the industrial dispute referred by the appropriate government, any referral points of disputes are formulated and generally initial burden lies with the management to justify their action against the workman. The position of legal burden to prove the issue in the case of such and such general lies on the petitioner workman under principle of section 102 evidence. Moreover, for fault on the part of the lawyer, a bona fide litigant should not suffer injustice. It is also well settled that when both parties adduce evidence on specific issues, the burden of proof becomes academic. From oral evidence of MW1, documentary evidence, it appears that WW1 was charged for remaining absent from work without any information to the management authority, and he also allegedly misbehaved senior assistant of the mill and created turbulent situation in the mill campus. The management had issued shock cause notice upon him and ordered domestic inquiry. It appears that Exhibit B, B1, B2, B3 shock cause notices were issued upon the workman. WW1 submitted exhibits such and such, replied against the shock cause notices. It appears from WS of the management that workman did not appear before the domestic inquiry on date fixed for the purpose. The management side also has not submitted the findings of the domestic inquiry report, although there is a limited scope for review.
Mr. Nath,
My lord.
since this is ultimately the reference, this is a reference case, isn't it? The reference is about the validity of the dismissal,
Dismissal,
dismissal, whether it's justified or not.
Justified or not.
Now, the case laws in this regard are all well settled.
Yes, yes.
That in such a situation, the workman or the management, you can, if you want, you can rely on the domestic inquiry. If you don't want to rely on the domestic inquiry, then everything has to be proved in the labor code. This is the trend.
Yes.
Now here in this case, you relied on the domestic inquiry or you did not rely on the domestic inquiry?
No, we relied on the domestic inquiry.
Then
We relied on the domestic.
if you have relied on the domestic inquiry, then the court has to frame that as a preliminary issue and test the validity.
Here, yes.
That has been done or not?
This has been, the issues have been framed there.
Where are the issues?
Page number, my lord,
So
lordship.
this is on the merit.
Yes, kindly see the issue is page number 166.
Page
166. Issues have been framed.
These are not, this is not the preliminary issue.
No, this is not preliminary issue. It was not framed. The preliminary issue, it is there.
In your written statement, did you take that stand or not?
My lord, that is.
Because you see, Mr. Nath, if you don't, if you on your own do not ask for a preliminary discussion as regards the validity, suo moto the labor code need not. That decision is also there.
Yes.
I don't think I've carried all those decisions today with me,
Okay.
but I have it.
Okay, my lord. My
There, these decisions are all there. Cooper Engineering is there. You know that old.
Yes.
They were all Nita Kalpesh, 1999.
My lord, my lord.
In details, this has been gone into.
Discussion has been made.
Discussion have been made.
Yes, yes.
So, even Justice Bhuya's judgment is also there. I think that is in the case of Assam Company of our
My
court, of this court.
My
You
lord.
know, sitting
Yes.
in a coordinate bench of this court. Right?
Yes.
Now, these are a very settled position that when a reference is made as regards the dismissal,
It is on the basis of application of the Workman.
be that as it
Yes.
may, you see, you both have to file your written statement.
Yes.
Correct?
Yes.
Now, management, you have an option.
Yes, my lord.
In the event you have already held the domestic inquiry,
Yes.
you can rely.
My lord.
If you rely, you say, now I'm relying on this. Then the labor and ask that you test that. Then the labor court will test it. The
Yes.
labor court will only
Yes.
see whether procedural has been done or not.
Yes.
If the labor court is satisfied that yes, it's valid, end of the matter.
Yes.
If the labor court comes to a finding in no, it's not valid,
Yes.
there has
Yes.
been procedural irregularities,
Yes.
then the labor court will have to give a fresh opportunity to both parties to adduce evidence fresh
Yes.
before the labor court, as
Yes.
if the labor court is only going to now
Yes,
see.
that has been done also in this case.
Huh?
That also has been done in this case.
Done.
We filed WS and the labor court has done that. Page number 163 can be seen.
So after that, why then again the domestic inquiry? They are saying the domestic inquiry.
Actually, the law settled is, my lord. The labor court could have taken this issue and settled the matter, my lord. Instead
No,
of saying,
I'm just, if I am not wrong, you just showed me that the entire, correct, the management conducted domestic inquiry by observing all female proceeding whenever offense went, so it was found that so and so. Accordingly, the application was terminated.
I think last part, lordship may kindly peruse. It is there. That will make the picture clear.
Which part?
If we go from, my lord, page 169 on.
I have just seen just now.
Domestic-
Yes, here.
Hmm.
Page 171. Then
171, yes.
why did then the labor court have said that the management ought to have produced all the documents of domestic inquiry?
My lord, first line kindly see. All the documents of the domestic inquiry, number one. Number two, report to the inquiry officer. And third one is second notice, my lord. These three documents, except inquiry report, both are there in this, marked by the labor court, my lord. Page 168, kindly see. All the documents of the domestic inquiry. Please, no, 168.
Yeah.
168, kindly see. 168.
Yes, it's all there.
All exhibits is there. The labor court says all domestic. Then kindly see, my lord, second notice, my lord. That is exhibit B9. Exhibit by the labor court, marked by labor court only. And the labor court says, my lord, documents not produced. That is true.
So even if the documents not produced, the labor could have
Would have done that.
gone
This is
into
judgment.
it.
This is judgment. 1957.
Correct.
There. I brought that one also.
It's very old.
Very old, yes.
Then
There are so many
changed.
came.
For engineering,
Latest-
Delhi
yes.
Cloth House.
My lord, even the Uttarakhand.
78.
Uttarakhand in 21.
78, Delhi Cloth House.
So many. So here, in spite of
Yes,
marking,
ma'am.
Lordship, I am also not satisfied the award because I was claimed only reinstatement and full back wages. But due to not filing the domestic inquiry by the management, the labor code award passed that the workman did not cooperate the management in the domestic inquiry, so he is not entitled to back wages. The management is directed to reinstatement in service within 3 months and his 3 increment will be stopped. It is clear. So this award is also not satisfied. I pray before this lordship for a fresh award, for fresh proceeding, lordship.
no petition from our side.
Because domestic inquiry report is needs for justice.
Are you the appellant? Have you come before this court challenging the award?
No,
Have you challenged the award before this court?
no, lordship. But this award, I am also pray
No,
before.
I
you not get
understand.
better for
I
fresh
can
award.
only sympathize your position. What else can I do, ma'am? You are not challenging the award.
Yes, I know it is lordship, but
You are not challenging the award.
But
Are you challenging the award?
No, lordship,
No.
no.
No. And they are challenging. Now, in that challenge, we don't know what we'll do. I may allow it. I may not allow it. Suppose I set aside the order of the labor code and I might just leave it there also. If you wanted, you could have challenged it, a counter challenge. That's your right, your prerogative. It is not for the court to advise you of your rights. But as officers of the court, you cannot now play the victim card before this court. That this should have happened, that should have happened. That you don't do. You could if you were dissatisfied with the award of the labor court, you had all rights to bring an appropriate challenge before this court. No one prevented you, right? But however, it seems you don't have any other objection as such as far as the award is concerned, right? But Mr. Nath, for this court to finally adjudicate the case today, I need the proper dates and the documents. Is it available with you today? If not, then you please, Mr. Bora, otherwise you give a
Leave for
proper.
dates, my lord.
Yes.
I have, but I'll just.
Then do one thing. What we can do, Mr. Nath.
have-
Mr. Nath, let us do it like this. I post it next week.
Yes,
Keep
yes.
it part-heard.
Yes.
You give a written note synopsis or something.
It's better.
But please give it in sequence, Mr. Bora.
Yes, 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 yes.
You see, otherwise it is not clear right now.
Yes.
It appears something, the award is not correct. Prima facie, I have understood that. But
Systematically,
it is not clear.
My lord, I asked my learned friend the other day, in the petition when I read, my lord, page 61, and next page is 173. That's why I made a notes here, and I was thinking how to tell your lordship, my lordship will catch me.
No, that's all right. So, Mr. Bora, you prepare a short synopsis, and you see, because these matters are very procedural.
Procedural,
So
technical.
and I would like to place them in the by dictating the order. So you give me those in the labor code. I'm sure the labor code proceedings
are
have
here.
come.
Records are here.
If required, Ms. Rupak, you give him the. You don't take it out.
No, we'll
but
just verify it right now, my.
you have a look at it and flag mark it in a piece of paper. You just write it down.
Yes, we'll
Then,
do it right now, we'll do it.
You do that. You don't have to do, Mr.
My
Nath.
lord,
Your juniors will do it.
Mimi is my lord, my friend. My lord.
Let your office do it. Heard in part, let a written synopsis be presented before this court on the next date of listing. Relist next week again. I think I'm going to be in a division bench.
Never lordship is in single bench, my lord.
It's very difficult to keep it like this. Let us say next week on a date to be fixed by the registrar. So
Yes.
in that way it will be convenient. Next week you can give it, I think.
Yes, my lord.
Huh?
No, it's my lord. My other thing is almost just to synchronize it. That's why.
And on that date, whenever the matter comes, suppose I'm in a DB and there are a lot of matters and it is difficult for you to wait, ask Mr. Bora or any other junior to inform the courtmaster. That much accommodation will be given to you.
A lordship's court is might always be for us.
All right.
Obvious.
I take it on naam to clearly. Your name is Ekalita, MS Ekalita. So date. It'll come next week, huh? নালাগে কাৰণ ডিভিজনত থাকিম না গম নাপাব কিন্তু
23
এইটো চিন্ময় কৈ পেলাই নাম ফাইলটো হেৰি কৰি থব What is this? Inclusion of name in VRS.
The petitioner is a permanent employee of Dispatch number 1, Assam Police Corporation Limited. All the other employees have been given the VRS benefit, your lordship. Actually, there are under case going on, and they have already order has been passed, giving the order VRS amount. Only the petitioner has been excluded, and the opposite side has filed affidavit opposition. They've taken the stand that the petitioner has not reported duty, and that's why the
VRS
has not been given. But without issuing any disciplinary proceedings, without giving any so cause notice, they have taken this decision, your lordship. And we have already given several representations before filing this petition. Those have not been responded. So at the outset, there is no order denying the VRS. So if they have some official meeting and they have not communicated to me, so that means that the communication actually is non-existent in law, your lordship. There is a settled law. So. And also there is, because they have taken this decision unanimously without giving an
Where is your decision of not giving the VRS?
Lordship, here I appear for the Corporation Department. Now the petitioner was an employee of the APOL.
Of?
Assam APOL, Your Lordship, Assam Polyester Organization Limited.
They are not a party.
They are a party, but that particular APOL is under liquidation. Now the liquidator is the officials of the Corporation Department. So on the last occasion, I have been asked to get instruction from the liquidator whether the name of the petitioner can be included. Now, what I have received is that, Your Lordship.
What is it? Tell me.
It says that, Your Lordship, way back in the year 2022, a 15 days window has been given to the aggrieved employees to approach the liquidator. That particular time frame, the petitioner have never approached the authorities. And moreover, prior to that, when the board was functioning, when the BOD was there, they have taken a resolution.
Why don't you bring this by way of an affidavit?
Lordship,
Let them get a chance.
Lordship.
Heard Mr. J. Das, Learned Counsel for the petitioner, also heard Mr. G. Borderlet, Learned Counsel appearing for
Respond number 2, 3, and 5. Your Lordship.
respond number
2, 3, and
2, 3, and 5. In view of the order dated 11/11/2025 passed by this court, whereby Mr. G. Borderloy, Learned Standing Counsel, was granted 3 weeks' time to obtain instruction as whether the name of the petitioner can be included in the list of payment of VRS scheme in the liquidation proceedings, in the ongoing liquidation proceedings, comma, an instruction has been received that the petitioner, having not approached within the time frame provided for approaching the liquidator, the name of the petitioner was not included. Let the aforesaid instructions be placed on record by way of an affidavit released on such and such date.
Only one date may be fixed, Lordship. It is going on for some
Mr.
time.
Counsel, why you prepare it and without hearing the court, you want to just submit that? I said relist on such and such date. Such and such date means the courtmaster is giving you the date. You just do not have the patience. That's the problem.
I apologize.
Yes? Very good.
Highly obliged.